lines. Looks like it's all there?
Yeah.
Okay, great. Hello, Jeff. Yeah, not too bad. Good. Yourself? Oh, okay. Okay, let's see. So I guess right now, I'll pop on over. Okay, thank you. There we go. Oh, yeah, I need to get your thing back.
Yeah.
Oh, and let's bring that back up. Ready.
Great. And
Oh, you don't have to put this up.
then I'll just pick up
Yes,
Great.
it's Bluetooth. So,
Yeah.
are you familiar with using this or familiar
just
with this one?
press the forward arrow to make it advance.
That's
Great.
just the back arrow one.
Yeah.
That's the really disco laser pointer.
Oh.
And these two buttons here, avoid pressing those by accident. Just avoid pressing those.
Okay.
I don't know. I just tell you what they do. So.
Okay.
Okay. This first one here looks like an escape F5 kind of thing.
Oh, yeah.
Okay, what happens if you accidentally hit this one? It will go to get you out of slideshow mode. You see your slides here. You see the editing stuff right there, right? Okay. Now when it's out of slideshow mode like that, you press that again. It brings you back to slideshow mode, but only brings you back to the very first slide.
one. Okay.
Right?
Don't want to do that.
While in slideshow mode, this little button, it's the B button or the black button. So basically, everything's go black both places.
Oh, gosh.
I think that's the idea, just to take focus, off the slide
Right.
and bring it back to you, right?
Right.
And then if you press that again, you see everything again.
Right.
So that's why I generally avoid those two buttons.
Yeah. Okay. Got it.
Generally, unless that's your plan.
No, but if it happens, I'll act like it is, right?
Yep. Okay.
Okay. Thank
Great.
you very much.
You're welcome. Thank you. So you guys are going to present from the table down there?
Probably
Yes.
Okay.
You got that.
Oh yeah.
Okay. Okay, I need help next door with one of my instructors, but I will be back.
No, you're fine.
I've got another hour. Oh yeah, there's a half an hour break in between, right?
Yep.
No, there isn't.
I'll tell him
Now listen, don't worry
to
about it.
hold it.
Yeah, okay.
I can say, my wife isn't here, but she might as well be.
That's right.
What version did you have? Cannot go. No, I cannot help you. I'm afraid you're not. He's talking to himself. Presentation 16. That's not the first presentation.
You betcha, Penny. Thank you. Thank you for hosting.
Putting on slides out.
It's kind of nice, isn't it? Yeah. But you don't get to travel.
No, that's okay. Next year, Hawaii. Yeah, that's right. That's right. Well, maybe there'll be some food. That's right.
I'm sure there will be. But probably not that exciting at that point. Well, and one of the other interesting things is what can we ethically provide in terms of information and assistance.
Just because all kinds of some grower working with the taxpayer $185,000 in $20.
Of course.
So that's just part of what it is.
Sure. Thank you.
Okay, we're about ready to get started, and Sue is going to come up, and I'll turn the time over to her.
You want to wait?
A few more people may trickle in, but we're going to go ahead and get started. I'm very pleased today to welcome our two speakers who will be discussing the Limited License Legal Technician Program here in Washington. We first have Jean McElroy. Jean graduated from the University of Washington School of Law in 1983 and was admitted to the bar that same year. After working in the King County Prosecuting Attorney's Office for 5 years, excuse me, Jean began working at the Washington State Bar Association in 1989. Excuse me. In the Office of Disciplinary Counsel as Disciplinary Counsel. She's now Chief Regulatory Counsel at the WSBA, in which she manages and oversees bar admissions, licensing, and continuing legal education. Judge Paul Bastine who does not prefer to be called that. He would prefer Paul. Graduated from Gonzaga University Law School in 1964, served in the Peace Corps for 2 years before returning to Spokane to work as a deputy prosecuting attorney in that city. He served as presiding judge for the Spokane County Superior Court in 1998 and became the first family law judge in 1999. And served in that capacity off and on through 2005 when he retired from full-time judicial work. He served as a pro tem judge until 2010 and now serves as a private trial judge and mediator. He is most particularly involved with access to justice efforts, having held various appointments with the Legal Foundation of Washington, the Spokane County Bar Association, the Practice of Law Board, and Team Child. In 2011, he was elected to the Board of Governors of the Washington State Bar, and he has received numerous awards, including the 2004 Judge of the Year Award and the Distinguished Judicial Services Award from Gonzaga University in 2005. If you would please help me in welcoming our two speakers. Thank you.
Thank you very much for inviting us to speak with you today. Washington State is very lucky and very excited to have the LLT program, which is really the first program of its type in the United States. Although I have to say that Washington State has had a limited license to practice law for approximately 30 years. We do have limited practice officers who are permitted to select, prepare, and complete documents to close real estate transactions. So in essence, although we bill this as the first, this is actually a second limited license to practice law in Washington. But it is a different path and a different road that these folks travel. Just want to say up front that we really appreciate questions and strongly encourage you to ask as we're going through, because I think it'll make the presentation more interesting, and I like to address those questions as they come up. So now I'm going to let Paul start, because in addition to being very knowledgeable about this, Paul was actually involved in the development of this idea and the rule from the very beginning. So he's very knowledgeable and experienced in this area.
It is an exciting opportunity for me to be able to talk to you. It may sound strange at my age to say that this is exciting. Generally, exciting for me means dealing with my grandchildren, contemplating a cruise in some warm climate, or dealing with nice homemade meatloaf. But the fact of the matter is that, as Jean said, I have been involved with this now for, I guess it's probably close to 14 years. And I'm going to give you just a little history. About 20 years ago, the state of Washington, along with a number of other states, began investigating the issue of how do you define the practice of law and what is the practice of law. And you all are certainly familiar with the fact that over the years there has been an increasing opportunity for non-lawyers to engage in what technically would be called the issue of practice of law. For example, probably about 30 years ago, the Washington State Supreme Court had a case called Cultum versus Heritage House, in which the Supreme Court was called upon to determine whether or not the completion of earnest money agreements or buy-sell agreements by real estate agents was in fact the practice of law. Well, a careful analysis caused a yes vote with regard to that. So very simply, filling out that kind of an agreement, which is filling in the blanks on the legal form, choosing a proper legal form, constitutes the practice of law, and the Supreme Court found that to be the case. It happens all the time. You go to the hospital, you get a directive. The hospital is in effect, or whoever gives you that directive, is in effect doing some things like the practice of law. So as we began trying to define the practice of law, the ground rules sort of became, how do you provide ethical, competent legal services to the public? How do you protect the public from the unauthorized practice of law? And yet, how do you not unreasonably restrain trade? And indeed, in Coltham, for example, the Supreme Court said, no, it's obvious we can't stop real estate agents from filling out blanks, and the other examples, and you can think of many of them yourself. So in 2001, General Rule 25 was adopted, which established the Practice of Law Board. And I was fortunate enough to be able to serve as vice chair of that board for 7 years, starting in 2001. And the Supreme Court delegated to that board the authorization to investigate allegations of the unauthorized practice of law, which in the state of Washington is a misdemeanor. And so it is a crime to engage in such activity. The Practice of Law Board was also authorized to issue advisory opinions regarding areas where non-lawyers could engage in performing legal services. And the examples I gave you, I think, are two of the ones that are pretty obvious. The third authorization was to make recommendations to the Supreme Court regarding how non-lawyers could engage in certain defined activities that would otherwise constitute the practice of law. Well, after a relatively short period of time, our board, which I'll get to in a minute in a later slide, came to the determination that we really needed to be able to have some kind of a way to assist the public far beyond these individual cited cases or whatever. So as a part of what the background, or a part of the background, was that in 2003, our Supreme Court had authorized a civil needs study. And the civil needs study showed, it was one of the first in the country, but it showed that about 85% of low-income people at 125% of the poverty level, that about 85% of them did not receive appropriate legal services when they needed them. It was not surprising that it was found that some of the areas that were of greatest need were for moderate income and low income people, were in the areas of housing, family law, and consumer needs. Based upon that study, then, we began with the directive from the Supreme Court to draft a proposal which we called the Legal Technician Rule. And in 2005, the Practice of Law Board had put together a general package with regard to this and proposed that we move ahead with such a proposal, in fact, licensing non-attorneys in some fashion in certain areas as long as they were properly trained. Well, I can tell you that I still have scars. People who took a look at this were not, well, let me back up. I shouldn't be as general as saying people. There were certain vested interests that felt their livelihood might be threatened by this. And as a matter of fact, the Board of Governors, which is the operating body that directs the Bar Association under the auspices of the state Supreme Court, in March 2006, the Board of Governors, who was funding the Practice of Law Board, decided they didn't like what we were doing and voted that we should not proceed. They didn't do it quite that way, but it was obvious that they were not happy with what we were proposing. But we went out, and we, being the Practice of Law Board, we felt we had the backing of the state Supreme Court. We went out and we talked to various interest groups, stakeholders all around the state. And And we proceeded to put together this package. In the process, we investigated what areas of practice of law might lend itself appropriately to the legal technician rule. We set up 4 committees to investigate the areas that we felt might be appropriate. The first was immigration. Well, you may know that there are some non-lawyer activities authorized under federal law in the area of immigration, and it was felt after some investigation that immigration itself is not only a complicated area, but in fact it probably was not an area where there was likelihood for someone to be able to make a livelihood or to proceed appropriately. Landlord-tenant was investigated, and indeed the subcommittee on that area came to the conclusion that this might be an appropriate area. Elder law, likewise. Some investigation indicated that this might be an area in which it would make sense to proceed. But family law, based on the Civil Legal Needs Study, and based upon what we knew was happening in courts, what we knew was happening generally with low-income and moderate-income people, was viewed as the most likely area in which we might proceed. So in January of 2008, we, being the Practice of Law Board, reported to the Supreme Court on the proposed rule. And we recommended that the initial area be family law. Now, in the state of Washington, and I think this may be true in most other states, we have uniform forms that are required in family law matters. And so to some extent it was based upon the needs, based upon the ability to use family law forms, based upon things like self-help books that were out there in the atmosphere. It was determined that family law was a logical area to proceed. So in January 2009, the Supreme Court published our first proposed rule with regard to proceeding with a legal technician process.
So you might notice on the slide that there's about a 3-year time period there. And you might wonder, what was going on during that time? Well, there were several things going on. I mean, as you've heard, this was a real challenge for the Washington State Bar and for the members, and yet it was something that appeared to be very seriously needed. Nobody can question the need for access to justice resources being made available to people, and part of what was going on during this time was lawyers in this state were saying, well, let us give us a chance. Let us try to meet these needs. And some of the things that were happening were there was a young lawyers committee out of Spokane area who was proposing a program that was designed to take young lawyers and use them to meet some of these needs. Additionally, the State Bar Association was attempting to set up and get running a moderate means program, as we call it, which is a program that's specifically designed to help people who are in that 200 to 400% of the poverty level, in that range, provide them with legal services by combining lawyers who are willing to reduce their legal fees with a way to get access for the clients to those lawyers. So these things were going on at the same time. Progress was slow, and basically the court eventually concluded that it was insufficient. The other thing that was going on was at a certain point, it became pretty clear to the staff at the Bar Association that it was likely that this rule was going to be adopted. It was likely that we were going to be asked to administer this program. And so we had to sit down and look at the rule as written and say, is this something that we could actually administer? And so at that point, I got involved and my staff got involved, and we actually had to look at it from the viewpoint of, okay, what does it say about what's required to be licensed? And how do you get admitted? And what are the tests going to be like? And what's the educational requirement? And, what do you do every year after that? Is there going to be a continuing education requirement? All of these things that go into essentially licensing lawyers were questions that had to be considered for licensing this new type of legal professional. And so we set about trying to come up with a scheme, at least a basic framework, where we could actually administer this new legal professional program. And so drafted some proposed amendments to the rule and sent those to the court, and they eventually were adopted. Now, does that mean that those rules were perfect? By far they are not, and we're not, and we are in the process of amending them regularly as we come across new issues that come up. But it was a place to start and a framework to start with, and that was what was needed to get this going.
As a part of that, you'll notice from the slide, the name was changed from what we started with as just simply legal technicians to limited license legal technicians. And I think the purpose there was to alert the public that this is a limited license. And these legal technicians do not have the authority to engage in the full practice of law. Just as an aside, once the area of family law was chosen, the sides were chosen also. And I can assure you that family law attorneys in the state of Washington did not embrace this rule unanimously. There were some who accepted it, but by and large, there was an area of discomfort from their perspective.
So in June of 2012, the Washington Supreme Court issued an order adopting the rule, and if you have never read this order by the Supreme Court, I strongly commend it to you. It is a pretty thorough description of the state of access to justice resources in Washington, about the needs, the legal needs that poor and moderate income people face. It was a pretty good summary of our legal needs study that had been done, and it makes some pretty compelling reasons reading, and it gives some excellent reasons for why this rule was adopted. You have to remember, of course, that our Supreme Court justices are all lawyers as well, and so, for everybody involved, this is sort of okay, wake up. Doctors went through this. They have physician's assistants and nurses, licensed nurses practitioners, and they have all sorts of, other levels of medical professionals. And so it's sort of a question of, get your brain around the fact that there is not just one brand of legal professionals. There are now, and there are going to be several types of legal professionals, and that's what the court is essentially saying. The major goals, and it's important also to remember that this rule came in essentially on these two tracks, side by side. One is access to justice, making sure people have access to affordable legal help, and that there's sufficient resources available. And the second rail of this approach is we wanted people to be competent and capable practitioners. So we like to summarize it as it was important to have this program be one that was affordable, accessible to a number of people, and academically rigorous. And so those were the guidelines that we were striving to achieve with the development of this rule.
The Supreme Court delegated the institution of this rule to a new board called the Limited License Legal Technician Board. We, as you've already probably observed, we call it the LLT for simplicity. It's not particularly an acronym that we love, but it's a lot easier than trying to tangle your tongue around a bunch of L's. The board is composed of 13 people appointed by the Supreme Court as an independent entity, operating out of the Bar Association and staffed by and funded by the Bar Association. The members of the board are lawyers, for the most part, but includes 4 non-lawyers, including a legal educator who may or may not be a lawyer. The board was delegated to create and draft the operational details, and as Jean has indicated, the first big decisions were what would be the practice area and what would be the educational requirements. Now keep in mind that up to this point, everything that had been done was simply in the proposal arena, so that the work that the Practice of Law Board that I was engaged in had simply been to send a proposal to the state Supreme Court and ask them for their imprimatur, the authorization to proceed to put in place this mini bar association, if you will. And to a large extent, that's where many of the lawyers in the state looked, how many of the lawyers in the state looked at it then, many of them still do. Just as an aside, the funding for this comes from the Washington State Bar Association, which is funded by license fees from lawyers. So you can imagine, if you're opposed to the rule, kind of the push-pull effect that that has. Now, the rule does require that at some point, I think still indeterminate, that this program must be self-funding. And based upon what happened previously in the real estate closing area, where we have non-lawyers who are authorized and engaged in that program, interestingly enough, that program, which has now been in existence for 30 years, is it, Gene? That program makes money, and makes money for the Bar Association. So the theory is, the hope is, that somewhere down the road, before too long, we're going to be in the same situation with the LLTs. The initial practice area, as I've already indicated to you, proposed by the Practice of Law Board and ultimately adopted by the Supreme Court, is in the family law arena. The court approved that in March of 2013. And since that time, the Practice of Law, the LLT Board has moved forward. The board was appointed and has moved forward to put together the necessary framework to proceed in that particular arena.
So as you can see, the LLT Board has a lot of work before it, and one of the ways they're tackling that work is by dividing themselves up into these subcommittees. And if you look at the subcommittees that are listed on this slide, it might sound to you a lot like any state bar association or bar association in a state where they have regulatory functions. With the exception that the first thing that the LLT Board had to do is decide, okay, what are the limitations on this program? We're calling this a limited license. What are we limiting them to? What is the scope of the practice that can be engaged in? So you have to remember, these people are not required to go to law school. They are not required to even have a bachelor's degree. But they do undergo very specific and rigorous education, just specifically within family law. But there are going to be questions that come up that are just beyond the scope of what the LLTs can handle. So that was one of the first things, is deciding what is the scope of this? What are we going to say they can do? Admissions and licensing, so what kind of education is going to be required? And what kind of a test? And who's going to write that test? Because the test does not exist. Even as we speak today, the test does not exist. So we're still working on that piece. The RPCs and some other descriptive functions of the LLT Board, The rules of professional conduct for triple LTs were considered to be, that was considered to be a vital piece of this licensing process. Because remember, part of the requirements for this program is we wanted to have competent and professional legal professionals who could actually help people and not hurt them. So protection of the public was very important. And so those rules have now been drafted and they have been sent to our state Supreme Court. So they are currently pending. They have not, I think, been published yet for comment, but they will be soon. And they're moving along. What the Triple LT Board decided to do is start with the lawyer RPCs, Rules of Professional Conduct, and run through each and every one of them based on the scope that had been set for the Triple LTs and discuss, does this apply to a Triple LT? Do the Triple LTs need to comply with these same duties? And that's a pretty arduous process. So what are some of the things that legal technicians can do or that they are required to have in order to be licensed? So they have to be at least 18 years of age. They have to have a minimum associate degree, level degree. They have to meet education, examination, and experience requirements. So one of the things I think you should have received a handout, which is called the Pathway to Triple LT Admissions. And that shows you what the educational requirements are. And we can go into those a little bit in more detail later on. But there are very specific paralegal educational requirements that are required, a certain number of credits and certain topics. And they all have to be completed. In addition to that, they have to finish 15 credits of law school level educational program in family law. And have partnered with the Washington State Law Schools, and particularly the University of Washington has been very helpful in this program. They are the housing for the program and take care of most of the details. So the Triple LTs have to go and finish this program, which is taught by law school combination. Each quarter is supposed to be taught by a law school professor in combination with an actual practitioner in the area of family law. And the reason for that is that we want these legal practitioners to have the ability to go out and actually handle people's problems day one on the street with their license in hand. They can actually go and do some of the things that probably even licensed lawyers might not be able to do very well straight out of law school. So that is the goal. Practical education along with theoretical legal education, possible because it's in a limited area. We also established that in order to qualify for admission, they have to pass a core education program, core education exam. And we opted to go with a national level paralegal licensing program. And so the exam that is currently being used is the NFPA Paralegal Core Competency Program. That's a baseline for being able to go on and take the other exams. Beyond that, we've now decided that they will need to take a professional responsibility exam, and they will have to take a practice area exam. And you'll notice we say a practice area exam because our expectation is that there will be more practice areas that will be licensed in the future. So the practice area exam will include multiple choice questions, essay questions, and practice exercise questions where they're given a library of information and they have to perform an actual function that they would have to perform out in the real world serving a client. In addition to that, they have to have 3,000 hours of substantive law-related experience. So they have an experience requirement, which again is not something that lawyers coming straight out of law school in most states are currently required to have. Because going into this program, there weren't going to be any people who were qualified in this way to be licensed. They did develop a way that currently licensed very experienced paralegals could get qualified to take these exams and get licensed. And that's our limited time waiver, and that requires, having passed one of the professional licensing exams for paralegals and 10 years of substantive law-related experience supervised by a licensed lawyer. So it is actually a very practical, focused, and rigorous program. Yes, there's a question back. Well, that's probably a very good question. The question is, looking at the number of credits that are required, 45 in the paralegal program and then 15 at the law school program, why would somebody choose to do this instead of becoming a lawyer? Well, it's going to be a lot less expensive, for one thing. We figure the total cost of all of the education in the one area is likely to end up at around $15,000 because the paralegal programs can be taken at the community college level. And so it will be a lot less expensive, and yet they will have a lot more experience and authority than a paralegal coming out of a paralegal program would have. So for those who might not think that they could afford law school, this would be a way for them to be involved in helping people with the legal system without having to actually complete an entire law school degree.
Well, and
are those quarter credits like at the UW, not semester credits?
Yes.
So
and what you will find in a later slide is that the law schools, the 3 law schools, are teaching the family law component, but the other portion is being taught at community colleges all around the state.
Is that then excluding the paralegal program at the University of Washington? Because it's not an ABA accredited program.
So the
That's
question
correct.
is if that excludes the UW paralegal program, and the answer is yes, that's not an ABA accredited program. The answer is yes for now, actually. And that is a topic that's under discussion right now, is whether other paralegal programs can in some way establish, if they teach these credit requirements, can they establish that their graduates should be eligible for admission into this program?
And in fact, in Spokane, while it was an ABA accredited program, it didn't fit all of our requirements in some respects. So they have adjusted their curriculum and adjusted their program to make it compatible with the requirements of the LLT. And the expectation is that that will occur throughout the state. There's no reason why the programs can't be integrated and adopted, and the program here certainly is one that I would expect very shortly will happen. The law schools are very interested in this because, as you know, law school enrollments are down, and this burden that lawyers have when they come out of law school is just almost insurmountable in some instances, particularly at the private law schools. So there's great appeal from that perspective for non-lawyers and for the law schools and the educational facilities to engage in it.
One of the areas that I am in charge of is the admissions for lawyers, and I can tell you I regularly see applications for admission to our state bar where people have, easily $150,000. I've seen some with, $280,000, $300,000 in student loans to get admitted to practice law. And, to be really honest with you, in today's legal market and with the vast majority of the legal jobs out there, and if you really look at the salaries that most lawyers make, we're not talking about the ones at the very top end, which is a select few out of the graduates, they aren't probably going to pay those back for a really long time. Granted, if you're talking $280,000, $300,000, that's somebody who's borrowed money their entire educational career. That's probably not just law school, but still, it's a significant amount of debt.
But also keep in mind that in order to enter law school, you have to have a degree. So you have already completed 4, or in my kids' cases, 5 years before you ever get to that position where you can enter law school.
Right. So some other things that triple LTs are going to be required to do, they will have to show proof of financial responsibility, which lawyers are not currently required to do in Washington State. They will have to engage in continuing legal education at a smaller course level requirement than lawyers currently are. They will have to abide by a code of ethical conduct, and as you just heard, those rules are now pending before our state Supreme Court, and they have to be subject to discipline. So we are still in the process of attempting to develop the rules for the discipline system. That will be one of the next phases. As you can see, this was pretty much get this rule in place, then make the program work. And so that's what we're scrambling to do and trying to do as efficiently and effectively as we can. One of the big drawbacks that we found was trying to figure out how they would be able to establish their proof of financial responsibility. Our limited practice officers, who I already told you have a limited license to practice law in real estate closings, they have 2 ways of doing that. One is by being insured by their employer, and the other is by submitting an audited financial statement every year showing they have a net worth of over a certain amount of money. Really what we were interested in here was trying to find a professional liability insurance provider who would be willing to cover the triple LTs, and it took some convincing, but we think we actually have found a company now who is willing to do that, and so we're looking into that much more seriously now. So we're hoping to have that in place before we license the first triple LT, since it is a requirement. So what is it that legal technicians, the triple LTs, can do? Currently, under the way the rules currently written, in the scope of what they're permitted, they can inform clients about the procedures and course of legal proceedings. They can provide approved and lawyer-prepared self-help materials. They can review documents and exhibits from opposing party and explain them to the party they're working with. They can select, complete, file, and serve appropriate and approved lawyer-prepared forms and advise of their relevance. They can advise clients of necessary documents and explain their relevance, and they can assist clients in obtaining necessary documents. So one thing we didn't talk about is specifically what has been defined as the practice of law in Washington State. So it is the application of legal principles and judgment with regard to the circumstances or objectives of another entity or person which requires the knowledge and skill of a person trained in the law. That's General Rule 24 in Washington's court rules. It includes, but isn't limited to, giving advice about legal rights or the legal rights or responsibilities of others, selecting, completing, and drafting legal documents which affect the legal rights of another, representation of another entity or person in a court or in a formal administrative adjudicative proceeding, and negotiation of legal rights or responsibilities. So out of those 4 things that constitute, by definition, the practice of law in Washington State, currently legal technicians are permitted to do 2. They can select and prepare legal documents, and they can provide some advice to their clients about the legal process and what can happen. They can't appear in court, and they can't negotiate on behalf of their clients. However,
Go ahead. You're the one in the hot seat on that one.
However, those issues are currently being looked at. Is that a sufficient range of options? Is that a viable career path for somebody? Are they going to be able to make a living doing these things, or does there need to be more? Is it unfair to their clients to say, oh, I can only help you with completing these documents, but I can't actually help you out in court where you really need me and where the judges really need you and need me, because that would be too far. That's beyond the scope of my authority. And currently, what happens when they hit that phase is they either have to say, I just can't help you in court, or they have to say, I can't help you in court, you need to talk to a lawyer. And so that's the limit that's currently drawn. But you never know. Things might change, and that is something that's under review.
And there's some indication from the Supreme Court that they're willing to take a look at expanding into that arena.
So as we just talked about, there are limits on what they can do. These are the limits that we talked about. I don't know. Does anybody have any thoughts about that? Is that too restrictive? Do you think somebody could make a living if all they could do was, tell you these are the documents that we have, and I can help you complete these, but I can't help you out in court? Does anybody have any thoughts?
If you could use it to drive down the cost of an ordinary firm, so they could retain 2 or 3 paralegals, like your analogy to a practicing physician. But I think even in that market, you see that there is no reduction in cost. Actually, if you look at medical costs, they're about 70% a year, 17% every 17 every year they've increased. So I'm not sure that you'd have savings, but that's the only way I think you could do it, that someone wouldn't get frustrated, especially in family law, where you can go anywhere from contract to taxation in one negotiation sessions. And I think it'd also be difficult because it's not uncommon for them to be facing a represented party that may have a lot more experience in the paralegal. So I don't know how you would get that kind of firm knowledge bank going with a paralegal unless they were affiliated first, because I don't think you have a critical mass of people that can pass that down. And I don't, but it would depend on what the educational model was when they were teaching them to see how it would work. But that's the only way that I think that it would work in terms of family. And I don't know what the need is in, say, King County or in Washington in terms of the state. In Utah, where I'm from, the family law attorneys in our council in our county bill a higher rate than most attorneys. Their billers are around $250 an hour, when most contract attorneys are only making about $170, can bill at the same rate. So I think it'd really depend on the market on what they could produce. So
it's interesting that LegalZoom.com, for example, and you're probably all familiar with that, or some equally internet-based organization, can help people in this regard for about $250. And so you can look at that as a potential market, I would expect. It's also interesting to note that in this first class we have of 17 people, is it, Jean, at this point?
Well, they're currently, I think, 15. We're
15. A number of them are people who are working for law firms, and the law firm intends to keep them on, and in fact, theoretically, provide it at a competitive rate. It's hard to know. You make a good point.
Comment here.
Before coming to work in Oregon, I practiced for some period in Illinois, and Illinois at least has a large oversupply of lawyers. And a troubling aspect to me seems to me, and you raised this to yourself, that lawyers are faced with high education costs, and then and a poor job market, and so that it seems like providing limited persons who could provide limited legal advice is addressing a symptom of a problem that without addressing some of its core causes, the cost of legal education and so forth, and so presents to attorneys a difficulty that you're now going to provide education to people who will undercut you on cost at a time at which the market is so poor, and that you're still required to be licensed to take on all these debts. And so how do you address the concern, as I'm sure this has been raised not for the first time, how do you address that concern on the behalf of lawyers that if you segment the market like this, it will make it very difficult for them repay those costs, and that I think the comparison with the medical profession is a little troubling because, of course, doctors have an undersupply and will continue to have an undersupply of doctors into the future. Why not instead focus on reducing the costs and offsetting the costs of providing full legal representation rather than segmenting the way in which people will provide representation?
Yes, we do hear that question regularly, and I think it's a valid point. I mean, how can we expect lawyers carrying a very significant debt load to be able to meet all the needs that are out there? There's absolutely no question that the need is there. Somewhere around 80% of the population appears to feel they have legal needs that aren't being met. And those are generally people who can't afford attorneys. And yet, how can we ask lawyers to charge a lower rate straight out of law school if they've got to meet these requirements that they've got? And so it's a very good point. But I think the answer has to come from, looking at the future. What is the future of the legal profession, and really trying to hone in on what is it that lawyers can do that others can't do? What is the unique skill set that we as lawyers bring to the profession, bring to the public, bring to the practice, and how do we identify that clearly enough that people who have legal needs will understand when they want to go to a lawyer? Because there's absolutely no way that a triple LT is going to be able to handle everybody's legal needs, or even in most cases all the legal needs of a particular client. And yet, how do we make that available and clear, and yet allow people to meet the unmet legal needs that are out there? Sort of the two prongs of why this rule was adopted by the Supreme Court. I think it's an excellent question, and I really, we routinely challenge our lawyers and around our state bar, the staff, we are constantly trying to think about and focus in on what is it that lawyers are needed to do? What are the legal skills? What are the ideas and the background and the training? What is it that we are uniquely trained to do? Or simply, what are we better at? And how do we inform the public about those kinds of things? And I think those are very valid questions.
Let me give you a personal anecdotal response. 30 years ago, when the limited practice officer rule with regard to real estate closings was enacted, my personal practice in Spokane, I had 6 paralegals working for me who did real estate closings, and I supervised those 6 paralegals. When the rule came into effect, it effectively wiped out that. And that income was about 60% of my income. The other 40% of my income was from my practice per se. After 2 years, and I no longer had any paralegals, my income had increased by 50% higher because I was doing real estate law, not paralegal stuff. And certainly it may not be totally equivalent, but that was my personal experience. And one of the things that caused me to believe that this rule probably makes some sense once the marketplace adjusts to it. I think you had a question.
Mine's kind of tied to the last question. What makes this preferable to unbundling?
Not necessarily anything.
Right. If we could just get lawyers to unbundle, and if we could get... One of the things that I argued starting in 2008 when people were complaining about this, the family law bar, get out and do it. Hire a bunch of paralegals. You can supervise them. You can unbundle. You can do these kinds of things. There was reluctance, and there still is reluctance to do that. So they allow the marketplace to deal with it by things like LegalZoom.com or the paralegal who advertises on Craigslist. If you go to Craigslist in any community, and I've done it, you find ads that say, I am providing this kind of service, and those people are making money. They came into my courtroom and did a botched up job, but people were paying them to do it.
There's a question in back.
I just want to know if I realize that they're still very new, but on claims or any malpractice issues, what kind of liability is
So we're actually further back from that, in that we haven't even been able to license anybody yet. We have our first class finishing their law school requirement this quarter. So they're taking their third quarter of family law at the law school. We hope to offer the exam next March or April. And we hope to be able to license some of our people who are currently in the program by that time, by the conclusion of that. So by late spring, early summer of next year.
It is a concern.
So will there be, insured, backed up?
Right. The question is what will be the requirements for making sure they're insured or backed up in some way? And yes, they have to establish financial responsibility, and that means they will have to establish that they have professional liability insurance. We do believe that we have found a company that is willing to provide such an instrument to the legal technicians, and in fact, they seem quite excited by it. So we're hoping that they might see that the people who are in the LLT program will be coming out with not just the legal education, but also practical hands-on experience as well, both from their 3,000 hours of practice experience that's required, and from the way the classes are being taught, which is to include this practical component.
My question was just related to that. In those 3 years, their 3,000 hours where they're supervised by a licensed attorney, are they running under the attorney's malpractice insurance during those?
I assume that the attorney, Washington doesn't require lawyers to carry malpractice insurance, but they would be working under the supervision of that lawyer. So the lawyer is responsible for the actions.
So I know we're getting close to 2:30. Maybe we should let them finish their presentation before we wind up.
So we talked about needing to define the scope of practice, and so these are the things that currently the LLTs will be able to do. Child support modification actions, dissolution and legal separation actions, domestic violence actions, committed intimate relationship actions, parenting and support actions, parenting plan modifications, paternity actions, and relocation actions.
Limitations will include not being able to divide up pension plans, businesses, real property issues, those kinds of things that might have significant dollar values. Those will have to go to an actual lawyer or be worked out in that kind of fashion.
So here are the admission requirements again. We've already talked about that, and this does not list the professional responsibility exam that will be required. This is a listing of the core education, the 45 hours that are required at the paralegal program. And so this did require several programs to modify the courses that they were teaching, either in the terms of the focus that they put on that course, meaning translating to credit hours, or in terms of offering like a 1 and a 2 in their classes. We will, as I said, we expect to be able to license several practice areas, and each practice area will have its own educational requirements. And that will have the core requirements, and then there will be additional educational requirements beyond that. We have a map here of where the different community colleges and law schools are that within this state. We're hoping to have a program that covers each area of the state. Talked a little bit about the limited time waiver requirements, and those are up there.
The law school curriculum taught by the 3 law schools is available online. So while it's live, it does not require you to come to the campus. You can do that from an appropriate online facility.
And then what is the LLT board working on? What were they working on in 2014 in some cases? They were working on the RPCs. Those have now been submitted to the court. They are working on the exam. We are actively writing the exam for the final family law piece. As I said, the core curriculum and the RPC piece. The core curriculum is tested through the national licensing exams. And then they're working on trying to define the next practice area. I think we're at the end of our time. And I thank you very much for your attention.
If you get any input, back, we'd appreciate it. Do you do any? Well, I think we would be interested if there's some way of doing this.
Thank you.
Thank you.
If you go out here on the other side,
PowerPoint advance.
yeah.
Thank you.
So this is
Yeah, so yeah. We'll see. If you guys want to, I don't know, you guys just. It's another kind of dance cycle over there. Yeah, you can do that. Cool.
Are you going to sing us at your university? No, you can. We'll just pass it around. So it's the same as our logic exam.
Space age look Space age look to it.
So is it 2010?
We have 12 questions about like what does it actually say? We've got it ready. Busing technology.
Yeah, something like that.
Yeah.
Well, it'll be better.
Thank you.
So what do we have?
Contact one of the power.
Sure.
Sure. Just passing them around. Just probably you don't want to.
Yeah, well, you want to go.
Let's give it like 2. There are a lot of people like that. I think people let's use the that's too. People let's use the restroom and stuff. They can be nice. They'll just talk faster.
Okay, that's fine.
Okay, good. All right. Cross state, right? I don't like that it's like smart. I think it's
We've got a puppet show. You're all gonna
We've now reached the interpretive dance portions. As you go flying off. No, he is. He is a great dancer. He is not saying dancer. Yes, that's right. That'll close the ovaries. Oh, that's interesting. Please, as your life coach, I know what I should be sending you. Your Christmas present. Or, no, actually, your winter solstice, because that would probably. No, this is a winter solstice. So actually, this is good because this way, okay, you can indicate a relative level of importance based on like Sean is obviously better. Yes, exactly. Yeah, there's a minute break from 3:30 to 4, I think. Is that right? And then 4 to 5 is the last session. Is the survey ready?
It is. Trying to remember.
Just make it. Keep up. You don't have to see it, just trust me. Yeah, we're ready. They'll settle down.
Okay, we're ready to start with the next program, and I'll start with introductions with Sean Nevers on the farthest end, and then Carissa Vogel, and then David Armand right here. Sean Nevers is the head of reference at Brigham Young University, which means that he oversees reference facilities, facilitates faculty research, and he oversees the library's electronic resources. He also teaches legal research. And he has several publications, and he maintains the BYU Law Library's blog. He's given several presentations, including AALL, and he's received several awards. Carissa earned her library science degree here at the University of Washington, and then she went to work at Columbia as a reference librarian and head of public services. And now she works at Cornell. She's the assistant director for research. And she teaches legal research, and she also has several publications as well. And then David Armand has an unusual title. He works at Brigham Young University. I just had to tell you his title. Senior Law Librarian and Head of Infrastructure and Technology for the Law School. So that's a mouthful. And he's also in charge of our building. We just had a major renovation, which he did last summer. So if you're ever in Provo, come see his work. It's great. Anyway, David has taught legal research, advanced legal research, law library management, and lawyer skills and advocacy. And just to know David's character, I asked him what I should say about him, and he said, just tell him I'm happy to be there. So I'll turn the time over to you.
Thanks, Bonnie. To start off this might be a little dangerous because it's getting towards the end of the day, but we're going to ask you to think a little bit with us. And the first thing we want you to do, if you have a cell phone or some kind of device, we have a short survey we want you to take, because we're talking about surveys, so we wanted you guys to be participants in that survey taking. But if you go to this URL here, lawlibguides.byu.edu/WP2014, there are some links on the left. If you click on any one of those links, we'd like you to do this right now, if you have your phone or whatever you've got, to go in and to just answer this short survey. What it's going to do, if you go into that LibGuides page, there's those links on the left, and there's several different resources. And what we'd like you to look at is to think, if you were teaching legal research in the first year curriculum, or if you're teaching the advanced, you could think about that as well. Which one of those three, which three of, I think there are 9, is that how many we have? There are 9 resources there. Select 3 that you would, if you had to cut something or de-emphasize something in your legal research class, what would be the top 3 that you would either cut or de-emphasize from your legal research curriculum? Give everybody just a couple minutes to do that.
Do it now.
We're going to use our best to try to use this. Penny, were you going to say something?
Yeah, I was just going to ask you, would you tell those of us who didn't bring devices today what the 9 items are, so we can actually think of what we would answer the survey if we can't answer the survey, or will that give too much away?
We'll actually get to that, we'll just we'll get there in about
Depending on how
6 minutes.
fast Sean talks.
Yeah.
Yes.
Yeah, we want you to participate. Yeah. This is just to kind of get us thinking about what kind of things should be taught or maybe not taught in academic law libraries. But we would be interested, those of you who work in firms or government, as you see attorneys. How many of you, do not work in academic law libraries? Just by show of hands. Okay. Great.
Cool.
Don't, yes. All right, while you finish that up, David's going to talk about that in a minute. I just want to begin so we can get going. We got a lot to talk about today, but the topic that we have today that we want to talk about are legal research practices of attorneys, and this is an area that I've been really interested in my work in academic law libraries as I teach legal research and get people ready to go out into firms or into government or wherever. And I think this is very applicable to I think all of us. We want to talk today about what attorneys are doing and try to see what kind of things how that affects the way that we teach in academic law libraries as we prepare attorneys of the future. Really, as I've studied this, I mean, the literature of our profession doesn't really show that we have done many studies on how attorneys actually conduct legal research. In 1969, Morris Cohen said that we know almost nothing about the actual procedures used by lawyers in their research into the law. And 35 years later, Dick Banner said the published literature on the subject suggests that we actually know very little about how lawyers go about their actual research. And there has been, I think in the last 10 years or so, some push by law librarians to begin studying attorneys and how they are researching. Just a few I've looked at. Stanford Greenberg has a survey where he looked at practices of attorneys. Judith Lee Hosett has written about how she's done interviews with attorneys. David and I have worked on some different standing focus groups that we've done with attorneys. Recently, Joe Lawson, a county law librarian, has written about a survey he did on how attorneys are doing research today. And what we're going to talk about today is another one that has studied practices of lawyers, as well as what law firm librarians think of how lawyers practice research, is the ALSYS Task Force on Identifying Skills and Knowledge for Legal Practice. That was a survey that was, the chair of that committee that task force was Susan Neville-Mart, and I was able to participate on that task force. And that survey went out. There was two similar surveys where we surveyed practicing attorneys as well as law firm librarians. We got about 600 responses from practicing attorneys from across the country, as well as about 150 law firm librarians that participated in this survey. And if some of you have seen this, and if you want to just Google it, you can Google ALSYS Task Force Survey, and some of the documents come up there. And what we wanted to do today was really get into some of that information and talk about what it showed and how we could, in the academic side, what does that mean for us who teach legal research? Should it mean anything? What could we change? And some of the questions that were asked in that survey, there was a whole section on resources. What kind of resources are attorneys using in their research? We also focused on research process, a lot of things on how you are actually doing research, where you begin your legal research. And then there was a whole section that talked about what are your opinions of how new associates are doing legal research? And we asked that of the attorneys and as well as of the law firm librarians. And so we'd really like to just kind of focus on some of those results that we found interesting, some of the things that it might mean for what we do in teaching legal research. I'm grateful for David and Carissa for being here with me. They did not participate in this survey as we designed it and drafted it, so they have hopefully more objective views. They can tell us where we went wrong in some things, because there are some weaknesses of the survey, and we want to go into those ideas of, are surveys in general a good way to go? Are there other ways that we can look at law attorneys and how they're researching and really get good information about how we should teach and what we should do in law libraries? One of the things, before I turn over to David, I just want to talk about is the question came up as we were doing this, and some of the other things I've done is, why should we care, right? A lot of the comments were, attorneys aren't good researchers, so does it matter how they're researching because they're not that good at it anyway? Should we really pay attention to that? And while I agree that some attorneys are not great researchers, I do think there are a number of attorneys that are great researchers. But the thing that as I've been thinking about this over the last couple of years, I think there are several very important reasons for why we should be studying attorneys and how they actually conduct legal research. I think when we talk about just the information environment and how quickly it changes, I mean, the attorneys are the ones that are seeing these resources and deciding whether to incorporate them or not. And maybe they decide to do it, maybe they don't. But the speed at which new resources are coming out, that it's important for us to stay connected, I believe, to the attorneys and how they are actually researching and what kind of research tools they're using in their practices. I think especially with the recession as well, when we talk about costs and research, I think that's changed a lot in how attorneys practice research. And we know that. We've seen the kind of a explosion of free and low-cost sources, and I think that will continue. But also just the idea that there may be things that we think are the best way to do things that really are maybe cost prohibitive now, or attorneys are finding ways around those and can still get the same types of information. Another reason I think is important to study is that when I looked at, there's a lot of surveys out there that look at law firm librarians and how asking them what resources out there, and I think that's great and very useful information. But what I've seen from my own law school is we're not putting tons of lawyers out to those firms or other areas that have law firm librarians. And so I need to know more of how the smaller and mid-size attorneys are actually researching so that I can help prepare my students better. And then finally, one of the things that I think is most important is just that when we talk about our students going out and being junior associates, it's the attorneys there that are actually judging the work of our attorneys, of our new attorneys and our summer associates, and understanding how they're researching and the opinions that they have of our students' research skills, I think is really critical for us that teach legal research. And so, none of this means that we have to take everything that they're doing and just do what the attorneys do. I think it's a great area that we can explore so that we can decide, what kind of things do we learn from practice that maybe conflict with some of the best practices we may have, and kind of do a balance, kind of figure out what is great about what they're doing, what is great about what we've always done, and meld them together so that our law students are better prepared to practice. I think that when we talk about some of the problems that are out there, maybe there are things that attorneys are doing that we don't think are most effective. Well, that's something we learn as we study the practices of attorneys. And there may be things that they're doing that we think, well, this may not be the best way to do it. Maybe we can focus as we teach on remedying some of that in law school. So anyway, those are some of the things that I'm thinking of, I've been thinking of over the process of this survey about why it's so important that we study how attorneys do research. And I hope that as we talk today, we can think about some of the weaknesses and some of the strengths. And my hope is that going forward, more of us will study how attorneys are researching so that we can have a better understanding in this information environment that we're in. Let me turn the time over to David, and then we're going to kind of jump back and forth.
So basically what we're walking through is sections 9 through 11 of the survey. And I don't know, how many, by show of hands, how many people have actually looked through the survey? There's one, that's great. 2, 3, 4, 5. Okay, it's sold. So just tell everyone else. We're going to leave for a while, and you can explain it to everybody else.
I have a paper copy.
Yeah, exactly, down here if you want to read it. It's one of these things that when you get a large survey, it's really difficult to know what to do with it other than to read it and say that's a really pretty pie chart. There's basically, in these 3 sections, 25 questions, so there's 125 responses that you have to figure out how to make it into what's called actionable data in business literature. It's like, what are we actually going to do after we've asked all these questions? And so, and one of the things that you find is that there's just a limit in terms of pretty pie charts when you look at it, what you can do. And so this is just a quick view of section 9. And so basically, as far as I could tell, since I didn't create the survey, it looked like it was trying to get at the distribution between the print market and then the free internet and the fee-based. Those are the 3 questions that they have. And if you look at it, it's kind of hard, at least, to see any great trends. The colors are pretty, and that's about as far as I could get just looking visually. When you actually break it down, though, in tabular form, you can start getting to see some trends that aren't visible when you're using the pie charts. And then to make it even easier to understand, I developed a method to combine the categories. And I don't know how many are trained in statistical methods, so I will deal with the 2 of you that are probably in the audience. Okay, you ready? So here we go. So the justification for combining the groups is that they're all now 3 the same distance away. So if you just have 3 categories, the categories on the bottom and the categories on the top are the same distance from the middle as the middle category. The other thing that happens, though, when you look at that is that it's a lot easier to see a trend. And I'll give you just 2 examples using this slide. The first is looking at how many people still use print resources. And to get there, what we would do is combine the occasionally and the frequent and very frequently, and so you get over 75%. So it's basically 3/4 of the people at some point are running the print resources that they're using. There's always a debate on how much time do you want to focus on print. I started teaching in a program that we did print first semester, and then second semester we do electronic resources. And with just an arrogance, I decided I'd try and do it just electronically.
and then I would do the print afterwards, which was epiphanal when someone was wandering down the stacks of reporters and we were doing it in print and actually figured out that little number in front of the reporter was actually a volume, which they'd never figured out, even though they've been doing Blue Book for a semester. But it shows that they're not going to, it would be an exception to not see print in an environment where they work. So it's something that you consider whether or not you're going to keep teaching it. The other is that in the lower right-hand corner of the slide, if you see 67%, it just confirms that fee-based resources are the most common used by attorneys. And there's been motion, and this we'll talk a little bit later when we talk about the free internet resources of the survey. It's the last section I'll cover. There's motion with Google Scholar because when this first was done, Google Scholar wasn't very popular, and Lexis hadn't developed a search system that made it easy to game Google Scholar so you could search Lexis, get charged for the search, but then click through using Scholar and actually read the cases that way. And so I think that will drive Scholar use for firms that use Lexis, at least the firms we've talked to it does. But that's why we try and make it easy to see the relationships by crunching the two ends. There is, I'm not the first person to do this, and unfortunately, we did see Mitt Romney on our way onto the plane. I didn't body check him though, so that was better than my experience with Mick Jagger. But it's the Bain Consulting Company is the one who actually came up with a similar approach of combining the low and the high end of a Likert scale to try and come up with some type of relevance. And we're going to talk about it a little bit deeper as we go down into the next portion of the stack. The first thing I just want to say is a disclaimer. I've used statistics as a tuning fork. It's just one measure and it's just one note. And you have to decide whether or not you're going to take action or not. Now, the classic example I can give you is those of you that teach, you get your course evaluations, the novice teacher always want to change everything. Thanks, Krista. Want to change everything based on a negative review. And our courses are really small. There are 25, 27 students. And if you have one negative review, that means you may be actually changing something that 24 students really enjoyed and found useful. And it takes time and maturity to start realizing that, yeah, that's what this survey said on this issue on this day, but this is the way that I want to use it. So in all these results, when we talk, we ask more questions probably than we're going to direct definitively. And that's why we want to do that initial survey, and we'll talk about it later after you see the findings. If that changes your mind, you may feel exactly the same way about what you would actually de-emphasize. So let me just make sure I hit page forward and page down at the same time. This is actually the other 13 resources in beautiful pie chart format. There's only 12 on the page because 13 where they get even smaller than they are right now. It's really hard looking at these. Go ahead.
I may be anticipating a future slide, but I'll ask this question. Two questions. Given that, at least from what I know, using any one of these does not preclude the same individual using another one of these, does the survey let you correlate or determine whether there's a correlation between a given individual using a subgroup of these? And do you ask a question in the nature of which of these would you turn to first?
And the answer is no. At least I haven't seen the full data set, but what I've seen is the reported results. It doesn't look like any of the questions were designed that way, and the analysis that's done. Basically, you've got a report out in these pie chart formats, and then you have a series of bar charts, histograms that will talk about weak significant relationships, and that's as far as it. And it looked like from the report out that the data set is limited, but I don't know for sure. But at least looking at the questions, each question is included in the survey, so you can read through it. I didn't see that you could develop a relationship study, at least not the way the questions were asked, and so. And you can correct me, Sean, if I'm wrong.
We have another section we'll talk about later about kind of beginning research, but they're not exactly correlated with these specific.
Yeah, we were just looking at sources, and so basically, when you break it into the 5-point Likert scale, it's still really hard to get any type of relationships. When I collapse it down, what I ended up finding, if it ever shows up, is that it's a little bit easier to see. And my method, again, is I heavily weight the downside, because when I'm teaching, I'm trying to figure out what I can take out. I just have too much to cover. And so when I'm developing learning activities, I'm always have a mind of what can we get away without to cover the time frame, not that much different than right now. And so what I do is I look at anything that shows up in the rarely or never category that is above 50%. And again, this is the idea of weighting the negative. And then anything that's in the very often, very frequent, above 10%. And the reason I do above 10%, again, the methodology is based on years as a systems librarian. The best features in the world that are only used by me disappear. So if there's not a market share, it doesn't matter that it's the best design ever. The market will drive what the vendors support. And so, but doing that, what this does is it lowers us down to 9, and that's why you have the 9. And here, Penny, is a list of 9 rank ordered, raw rank ordered, just from the least used to the most in this set. And so you can, they're familiar now because you've done the survey. They're pretty similar. But besides just ranking it this way, the other thing that I want to do is I want to give credit to those that aren't used very often, especially if there's a trend that they are. So if they had very high frequency of using frequently or very high frequently, or very frequently, what I would do is I'd subtract that from the amount that they were never used. And then that gives you a slightly different ranked order. And so you still have loose leaves at the top, and that shouldn't surprise people because they're pretty specialized, and this was a general survey. And then you've got ALR, which kind of shocked me. I'm from a school that we're a ALR digest kind of bedrock, and then it drops all the way down to litigation resources, which is just right over my cusp of even something that I'd worry about. But this gives you a lot more. There we go. Oh, sorry. This is one that's that we've now subtracted out or given the credit for things that are trending a little bit more used. And so loose leaf services, if you see, is very frequently used more often than ALR. So, but it's still the same. And then it gives you a weighted value of those that are less used than those that are used. And then from this, go ahead, you got a question?
Just a quick comment that we are preparing our students not just for practice, but also for academia. So it might be that...
What percentage of your students are preparing for academia?
If you're teaching a 1L, you're preparing them to be a 2L and to be a 3L.
Okay.
And so, you might teach law reviews because a lot of the students are going to write seminar papers, whether or not they will use law reviews in practice. You teach restatements because their contracts professor is talking about restatements, even if they won't use it a lot in practice.
Yeah, no, and I think that goes back to what Sean said in terms of the different reasons. I thought you were saying preparing them to be professors, and that percentage is a low order of magnitude. But yeah, the issue, we're just looking at the results of this survey of practitioners, and so I think keep that as a bookmark as a limitation of this approach. And so, but what I wanted you to do is go back to the same Law Lib Guides page. There's a tab that says reflection, and then based on what we just saw here, if you're taking this into account, would vote again and see if that would change. And you can vote using that footnote that, I'm not worried about what practitioners are doing at all. I want to concentrate on what would be most helpful for law students themselves. And then we'll look a little later, if we have time, at if there's any change based on what we see on the survey of what's being used from what we would actually teach. And I think that will raise, I think Sean and Crystal will get into this issue about what does it all mean. What do you want to do? Is there a professional responsibility as a librarian that we're going to teach many things that they'll never use in practice? My experience is that class time is so valuable, and we probably have one of the greatest opportunities of most law schools, I think any law school in WestPac, in terms of the total amount of time we spend with first-year students in class. It's about 1.8 credit hours, semester credit hours a year that we get just with our law students. And I never have enough time to cover what I think that they need to go out in the first year. And my goal is actually to make sure that they get a job wherever. And so, but go ahead and do that as we go, and I'll just flip through these. This is the second content section of what I was reviewing, and it's the actual internet resources, free internet resources. And we can do the same thing again by crunching it and then sorting it by what's actually available. And so, and what we see again, and again, it shouldn't make you stop having a law library website, but if your incentive or your funding justification is based on how much attorneys use your website, that might not be the best way to go. But just practicing attorneys don't find it that useful. They don't use it very often. The same with law firm websites, nonprofit org sites, and then this is the one with Google Scholar. But here's a classic example of the methodology of adding and subtraction. Even at the time of the survey, which is about a year after, probably about 7 months after Google Scholar had case law, you already got 15.7% of people that are using it. So to me, that indicates a trend. And the reason I like this trend is because then legal blogs were more useful to attorneys than Google Scholar. But if you give the credit for Google Scholar that's used more very frequently than legal blogs, what happens is legal blogs are less used than Google Scholar, which, again, in my experience, legal blogs are used a lot by academic faculty, and law students love to use them, but very rarely do they find utility in trial practice. And so, but that's, I think I get to hand the wand off, right, to you?
Yeah, I think it's my turn.
Okay, there you go.
My turn. Well, we'll see, right?
There you go.
Oh, yep, we're in the right spot. So that was a lot of numbers. Thank you, David. So I'm giving everyone a little break from numbers, and we're looking at a pretty picture. Yeah. Mary, you have incredibly good eyesight. So for the rest of us, we're just going to see pretty spines of books. So I'm going to start talking about the section of the survey where attorneys were asked where they started their research, and they were given 7 different skills or techniques where they were going to be starting their research. And what's interesting is that just over a third frequently or very frequently basically ask fellow attorneys, start with Google, start with a secondary source, start with in-house work product, or start with some kind of subject-specific practice guide. And Sean's going to talk a little bit more about the specifics within that particular data. I thought it was really interesting when I was looking through that the main trend is that more than half frequently or very frequently start with a statute, and by far the most, over 57%, frequently or very frequently start with case law. Now, to me, when I'm reading that, I think that's still indicating that we have a really strong case law bias that's built into the research process based on what they're seeing and what they're experiencing in their substantive law classes. So I know that a lot of times with my students, the default is, without really thinking, without doing any kind of research plan or process, they think that they have to go to case law first, no matter what the question is in front of them, and that bias seems to be carrying into practice areas. So there are 2 other things that I thought were really interesting about this, going back to the frequency or very frequency of some different uses. One was the Google question. So I saw that and I looked at it and I thought, okay, now are we going to see some kind of generational divide or some experience divide based on who says that they're never starting with that or who says that they very frequently start with that? And based on the data and looking at it a little bit more carefully, we saw that there wasn't really a great deal of difference for someone that had 10 to 19 years of experience versus someone having 5 to 9 years experience about when they might start with Google. Now, in real terms, Sean and I are the same age. We both graduated from high school in 1996. We didn't have the internet until late in high school and early in college. So we have a framework, and I know a lot of you are giggling about that. I'm sorry, I guess I shouldn't have called us out on our relative ages. I'm glad we did, because we were sitting right here trying to figure it out.
Yes.
I'm older than Sean. If anyone's trying to figure that out, and David is much younger than us. Yeah. So what I think is really interesting is I know that when we started out and when we were taught in grade school, like we had card catalogs. We went from the transition to little people still learning card catalogs to then having some computer experience to by the time we're entering college now, all of a sudden the internet is becoming more of a reality. And it wasn't until my last year of college where the kind of online syllabus and no paper syllabus became a reality. So what it says to me, so we would fall, in kind of the later end of that 10 to 19 years of experience. There's a divide. My brother is a couple years younger than me, so he had this very different experience. But we are both kind of equally comfortable in a certain way of jumping into to the Google world or thinking in that particular way. The place that we're still seeing the divide, which probably is going to be pretty obvious to all of us, is more when we're talking about people that have 30 plus years of experience versus people that have like less than 4 years of experience. Very few of the people with less than 4 years of experience reported never starting with Google. It was, or rarely, it was like under 10%. And people with the over 30 years of experience, over 25% said that they would never start with Google. So that was really interesting to me. The other really interesting thing for me in this particular data set was the reporting on using in-house work product. Now, I work in New York. I used to work in New York City, and I was very lucky to have been with a group of people that met every summer, firm librarians, government librarians, academic librarians. We could all talk to each other about kind of what we were experiencing with our new associates, with our students, kind of changes, trends that were going on. And I learned from my colleagues in firms and government that they tell their new associates, before you do anything, go to the in-house work product. Like, look at our website, look at our resources before you do anything else, because then we're only really worrying about your time. You're not touching any other kind of resource. So when I looked at the data and I saw that, especially for attorneys with little experience that were working in firms, that they were never really going there at first, I think is actually some actionable data that those of you that work in firms and governments and with those young associates, there probably needs to be a reinforcement of what it means to go and look at in-house work product and why that's important for them and how they can more effectively use that. So, and then Sean's going to go.
Yeah, I just wanted to build off of that as well, because one of the interesting things that I saw when I was looking at these are some pie charts on beginning research. The question was asked, how frequently do you begin research with a secondary source? How frequently do you begin research with in-house work product? And it was interesting to me to look at these and compare them, that really they're fairly similar, I think, in how the results turned out. And yet, when I think of how I teach legal research, I mean, there's a big focus on beginning research with a secondary source. And I mention in-house work product, but I haven't developed a way yet to really have that be something that we can practice and do. And so it got my mind thinking about these ideas of how can I include that, because I think that is an important area, an important starting point for research, as Carissa has mentioned. And we don't have a lot of time, but I was curious. I mean, I've come up with some ideas, but does anyone who teaches legal research, have you developed a good way to teach students to begin? Do you have any exercises that you do, or any ways that you've created your own databases to simulate this in-house work product, beginning with in-house work product? Or any ideas? Yeah, Vicky.
So no, I haven't.
Okay.
But I almost wonder if it should be part of a first-year curriculum.
Sure.
And I think I also worked in private firms before coming into the academy. And I do know that in-house work product procedures differ from firm to firm. And it's, I think teaching good core research skills will transfer over to using that in-house work product and allowing our colleagues in the private firms to take well-informed students and turn them into well-informed practitioners. So, we talked, or one of the speakers talked earlier about what do I cut? Right? We never have enough time because it's so much. It's like we want to transfer our brains into their brains. It's not going to happen. Right. And I think it's more important to reinforce some core skills rather than introducing work products that are specific to particular legal environments.
Thanks for your comment. Ben.
Would it make sense to have, in your class, conceptualize in-house work product as one subset of secondary sources, because they are, in a sense, secondary sources produced by their colleagues at your firm as opposed to a publishing house, but they're not the law. They perhaps more often than not are practical as opposed to a conceptual discussion of the law, but in some respect, depending upon how the firm works, they may be indexed, their table of contents might be similar to some secondary sources.
Or they might have situations where particular practice areas have particular separate sites that is going to house most of the work product, so that if you're in a particular subject area, you wouldn't even know what's going on for another one. Mary?
It occurs to me that students are teaching each other to use in-house work product when they create outline banks. And the Student Bar Association, tells the 1Ls, well, here are the outlines created by the 2Ls. So they are very quickly figuring out the advantages of using what somebody else has done. And they are also learning the disadvantages, that they miss something when they don't do their own analysis.
That's a great point.
Yeah, that's right.
Last one, then we're going to move on.
For the in-house work product stuff, when I talk about forms, like you might work at a firm there and they've got all their own form bank there where you're going to use that. And
sure.
I also sort of come in there and dovetail it with, it's not cutting and pasting. You actually have to read through the stuff and make sure everything's correct and all that sort of stuff. But I just touch upon it. But I'm a little surprised at those numbers there. So.
Yeah, I was too. Can I just say one thing?
Yeah.
So this year for our lawyering class at Cornell, we actually separated out our research class in its own separate website, so that all of the resources for our site, and we do a flipped classroom, so there are videos and assignments and other things that we might add for clarification, all live in that one place, so that the sense was we start getting them in the habit of looking at the things that are already provided for them before they jump out into the rest of the world to try to find information.
I think this is useful to think about how we can do it. I mean, when I was thinking of possibilities, I think you could compile a bunch of documents yourself as far as grab some briefs and different things and create a kind of small universe where they could, an advanced class perhaps use that for one of the resources. And I think it's just thinking of what might be a useful thing to simulate this, I think would be, at least for me, is something that I've been thinking about. So we'll talk about process.
So it starts to become obvious which slides are Carissa slides and which slides are David and Sean slides. So the next part was that we asked, or they asked attorneys how often they used specific 7 skills or techniques when they were actually doing their research. About 3/4 said frequently or very frequently. They follow sites and cases. That was by far the most. Over half said they frequently or very frequently looked at sites and annotated codes or sites that they'd found looking at secondary sources. And just over half said that they were using the index and tables of contents with statutes when they were looking at doing their research. So I think that I know that a lot of us have maybe switched around some of the things that we've done with teaching now, putting statutes before we're teaching case law. I think that that's kind of showing up in how people are answering this particular question. I think this is going to be a really interesting benchmark kind of survey, because things have changed so much, even in a really short number of years with Westlaw Next and Lexis Advance and their platforms and how they work. I know that when I got started teaching legal research, the first time I taught it, I was a TA at my law school, and searching for a statute was a nearly impossible thing. I think I had one person who was in the legislature in New Hampshire, and they had like the language of the legislator in their head. So when they were trying to search for a statute, it always came up like right away. No one could ever understand what was going on. But for everybody else, it was kind of a useless process, which is why we talked about going to the tables of contents and indexes. But when I was developing our class materials for this particular year, it's not hard to search for statutes anymore with a lot of the platforms. I mean, we're still going to be using them, I think, for the tables of contents and looking through to see where the statutes play together, but actually some of that like basic search functionality, I think, we might not be emphasizing it for that anymore. Another interesting thing that came up was, not unexpectedly, 19% of respondents said that they did not actually try to go to the digest and find a topic and key number when they started their research. But a lot more people said that they, frequently or very frequently would actually use head notes and topics and key numbers when they were actually looking at a case. That seems to make sense based on what we see with our students. It's just frankly much easier to find a case and actually use that to develop more information than actually jumping into the digest. And of course, as one would also expect, solo practitioners are not using the digest or head notes and key numbers very much at all. And I think that's probably just a sense of where they're going to get their resources. They're probably not buying the Westlaw subscription or the Lexis subscription. They're probably buying something else. The other interesting thing was the terms and connector searching. So that question was asked, and over a third of all attorneys said that they very frequently use terms and connector searching, and over 65% said that they frequently or very frequently use terms and connector searching. Now, I don't know about all of you, but my approach to teaching terms and connector searching is going up into a little bit of a revolution standpoint in that what's happening with the West search algorithm, it really is at a disadvantage if you try to do a terms and connector search on that first level. So we're actually going back to a place where we're saying, okay, for Bloomberg and Lexis, even in the new platform, it's fine to start out with terms and connector searching, but actually if you're doing it with West, start with the general first kind of overview search and then filter with the terms and connector searching after, because the results are just so wildly bad when you try to do that first kind of search level with the terms and connectors, and we just want to make it a little bit more clear for our students. So it's going to be interesting to see what happens. Now, my students love learning about terms and connector searching. Like they eat it up. I don't know if that's true for all of you. It's like they've just found this power tool. Like they were using like a hand screwdriver, and now you've just shown them, oh yeah, you could just have one with batteries and it works so much better. So I don't think it's going to be going away, but I think we're probably going to have a more nuanced approach again for terms and connectors. So Sean's going to talk about a little bit more of comparison now.
Yeah, so one of the last section of the survey, and this I invite you to take a look at this because we're just going to show a portion of it today, but asked the attorneys, and also we'll talk in a minute about law firm librarians, what are your opinions of new associates research skills in a couple different categories. And there are some, if you look at the survey, I didn't get into the I think it's the good side of it. They say that, new attorneys are researching well in statutes and cases and citators. But what I thought might be interesting to look at is if we look at what they say that new associates are researching at the level of unacceptably or poorly. I've selected the top 10 in that area. And you can see that, probably similar to what we would think, legislative history, administrative decisions, all these things are pretty high in the unacceptably to poorly range. Now, one of the things that this survey, as I looked at these results, didn't get at, and it was a weakness of this survey, and I hope that some of us can explore this more, it was just the idea that when you look at legislative history, yeah, almost 50%, that's bad. But we didn't get into the point of how often do you do legislative history work, right, which is an important consideration. And I think that's something to explore more. It's the same thing with administrative decisions, right? That's something that's probably more specialized, or maybe they have other people doing that. But those are some of the areas where attorneys are saying that it's not very good. But I mean, there's some other things when we talk about cost-effective research. I mean, that's something, I think we can always do more in that area. Chris and I were talking about it last night, where some court and government and firm librarians have said, try not to teach that because every firm is so different. And I believe that. We have to make sure that the students understand that every firm is different, every environment is different. But I do think there's different ways that we can encourage them to be a little more conscientious about what they're doing, that help them understand that law school is a place to practice so they can get better at their research skills. If you're interested in this, you can always help me talk to the vendors about this, but I've always been interested in getting Lexis or Westlaw to allow us to have kind of a limited information environment where we could have just cases and statutes for the students for a particular problem instead of the whole universe that we get in the law school environment. I think that would help us kind of say, okay, in this situation, this is the information environment that we have. Do the problem, right? And so they get used to kind of seeing the limitations that they have, whether it's costs, whether it's using only free resources, whether it's using a limited version of Westlaw or Lexis. And I think that would be a valuable research tool. So let's move on to.
Yeah. So I was thinking when I was reading over the comparison between how attorneys are saying that their young associates are doing research and they're being much more happy generally than librarians, the new associates doing research. And I thought this actually really demonstrates the perspective that I have as a research instructor who works with a writing instructor in the course of a lawyering program. So to illustrate this and think about this a little bit more carefully, I'm going to tell you a short story. So I had a student, we're going to call him Joe. His name is nothing close to Joe. And he came to me when he first got the open memo problem, and he was a wreck. He didn't really know what the problem was about. He didn't know what he was supposed to start researching. His plan, as far as I could tell, was to Google a little bit and then hope to find some case law citations and then start writing, because of course it was late in the process too. And he hadn't remembered about going to secondary sources. He didn't think about whether there needed to be a statute. He just had no idea what to do and no idea what questions to ask. And we met probably, I would say, 4 different times. And I know he also met with the teaching assistants in the class, because they would come to me and say, hey, what's going on with this guy? And so we kind of paired up and were talking with him a little bit. And a lot of times what we would end up doing by the end of our sessions, Joe and I, would be like kind of going through and clarifying what it was, like ask the questions, what it was that you had to find out, what you were looking for. Did you have to look for someone else for clarification, or did you actually have to go and do some research yourself? And of course, so I'm seeing it from that perspective. At the end of the term, the writing faculty member and I talk about the various students, and we rank them. And we had one place where we just didn't agree. I had Joe really low, and Joe was her top person in the class. And we started talking about this a little bit more. And she said, well, he found all the right cases, and he had by far the best memo, and he just seemed to know what was happening. And not only am I going to give him the best grade, I'm also going to ask him to be a TA for next year. And I'm thinking about this, and I'm like, okay, because she wasn't, Jolene, we'll call her Jolene. Jolene wasn't there. like Jolene didn't see what I saw when this student was coming in, had no idea how to do a research plan, had no idea how to construct something, didn't really know what kind of questions to ask, didn't have a sense of the secondary sources. So when I was reading through the results from the firm librarians and the attorneys, it wasn't necessarily as I was looking at, well, who's right or wrong, but man, they must see these people in very different kinds of situations. And probably have a little bit different set of expectations based on all of that. So it just made me kind of look at that data and think really carefully about like what my expectations are and what my end game should be when I'm looking at, you know, designing the various classes that I teach and what I should be expecting, and you know what's right, like not what's ideal, what I think might be the best, but what's a realistic place that I feel like all of those students need to be.
To go along with that, I just pulled out a few of these slides. I mean, one of the parts in 2014, the task force released a survey that compared the opinions portion of the law firm librarians and the attorneys, and the answers were wildly different in many different ways. And these are just a few of them, where we talk about attorneys and librarians, how they viewed the research skills. This is one: ability to research statutes. Able to research legislative history. We already know that the attorneys thought that they didn't do a very good job, and the librarians thought they did even worse, which makes sense, right, if you've dealt with anybody like that. Ability to use secondary sources. Again, these big differences. Even just understanding the difference between statutes and regulations. I mean, over 50%, or exactly 50% of the attorneys said they do great at that, and we thought otherwise. And I don't know if I have another one or not, but I think that might be the end. But it was interesting to look through this, and I think, as Carissa mentioned, we were thinking about expectations, right? What are the expectations that we have, and how do we view the students? And that was, as I was thinking, I thought it's really important to come up with learning outcomes for our class. Where do we want the students to go? What is it that we want them to achieve? Do we want them to achieve to be researchers like we're researchers? Do they have to just get to the level that the attorneys will accept them? Is there somewhere in between? I think there's a push, obviously, in AAO now on having legal information literacy standards. I mean, is that where we need them to get at the end of the course? So I think it's an interesting thing to think about how we view the research skills of these new attorneys or our law students versus what the attorneys think, and where should that come out after a first year, after advanced legal research class? Is something I think we need to be aware of and be thinking about. David, I don't know if you had one. Oh,
I do, but do we want to talk about the data first?
Well, we can. I mean, basically the great thing about the data, having two surveys, it shows how you can invalidate any survey. And the first is by having a small survey size and not having the same people participate. So thanks for the 17 who started and the 12 who did it a second time. But basically all we saw is that Mary is very persuasive in her advocacy. The loose leaf still stayed at the top of the list for most likely to be deleted. Case digest moved up one position to be more likely, and transactional resources actually moved down one below, and then restatements and legal encyclopedias stayed right where they were. But ALR and law reviews were less likely to be removed from the curriculum, and then sample legal forms and litigation resources were more likely to be moved. So there is some movement based on the survey, and my guess is if we surveyed it again in about 10 minutes, it might move another time.
So do we want to ask them at all why they might have changed, or if they...
Yeah, anyone did anyone change, or did anyone know of anybody that changed? So that way you're not put on the spot. But if anyone that changed their response, does anyone want to explain why they felt moved to change it the second time that they vote? Like what metrics were important to you? Because it clearly it can be the comments that people hear. It could be looking at the data, and so. But I'm just wondering if anyone is willing actually to share why they would vote different the second time,
or why their neighbor voted differently.
Yeah, or a certain person, an identified person. So. No brave soul. All right, one brave soul.
Nobody's answering that question, though. I have another question.
So I'll just conclude. No brace holds. Go ahead.
I'd like you to clarify what you said about WestPac Next. You clarify your statement about Westlaw Next and Boolean not working on the first level compared to other services, and is that what you were saying?
Yes. So
and why?
The West, well, I don't unfortunately know a great deal about the West algorithm because none of us do. But we were actually starting to just test our particular problems just to see what would happen, running the same search in all of the different systems. And so the West search algorithm that powers behind that first kind of search box on West, the results were not what was expected and actually not what they really should have been if you did a pretty developed terms and connector search on that first level. So based on our testing that we did of that, the way that we're actually teaching our students to work with Westlaw Next is to do a more broad search kind of up at that top level, and then when you want to get into more specifics, use the filtering once you get a result set, and then put in the Boolean.
Well, are you saying that like a /p then wouldn't necessarily find things in the same paragraph? What part of the Boolean is breaking down?
I think what she's saying is in the master set, this is an information technology general problem, in the master set that you get returned, that the sub-filtering that you do before you execute your search can actually decrease the precision of what the results are on the second page, or it can increase the precision on that immediate hit list that you get, where you're not seeing what you would expect someone to see right off the bat. And that's why you're just running into a collision with all the pre-sort filterings that Westlaw is trying to do on the side, and then how it's trying to build its rank order. And so you can compete against that if you don't know what it takes into account when it does it. By a terms and connect search, or say you're searching a field that if their solar index is actually deprecating that field, but you just increased it, you can cross-cancel it out. So a resource that would appear, say, on line 10 won't appear until line 60 or 70. And I think that's the behavior that, and you can do this even on Google. Google has the same problem, that if you try and game Google and use advanced search features, that you can get actually a very different result set than if you just take out of the blocks and type keywords. So.
But you can set it so that it will act as a normal Boolean searching.
You can set it
for the first level.
You can go into advanced search and you can do that.
And you can set it so that it will automatically be advanced search.
Right, but that's probably not something that we're going to have our students, our first year students do right away. The best thing is like knowing what they're going to be comfortable with, and then knowing what's happening with the algorithm. Let's give you the best tools in order to particularly do that.
And the issue is when you've got three competing search engines and two of them do it a different way than the other, it's easier just to note the difference and then to tell them that there's ways around it. But it takes a long conceptual distance to explain that, West has a very, this proprietary search algorithm and its filters work different, say, than Westlaw, and then they both work different, but than Lexis, and they both work different than Bloomberg. So and I think that's why the easiest approach is just to say, we discourage you from doing it now. You'll learn this tool later as you go. We'll start with this as a basic, and then you can fine-tune it later. And it's actually, the tricky part of doing that is that none of these algorithms are fixed, so they're still being tuned. And so it's what we have a library staff, the main library, that's constantly playing with our solar tuning. And so you just have to get used to the fact that, this search doesn't have the same results it did the last time I searched it. So.
And the last time I searched it might have been 2 days ago, and there's just different results coming back. Yeah.
One thing with that, I know with
Absolutely. Yeah.
And so that's one thing
Yeah.
is put a little thought ahead of time.
Yeah. Yeah, absolutely.
And then it's like interesting search that is within the same paragraph. That's about what the algorithm itself is doing. If your search terms and connectors is any narrower and tighter than that, then you're tighter than the algorithm.
Yeah. Thank you. Okay, so there's just one more thing we were kind of going to get into, which is the idea of what what we could do to test, to look at things in a little bit deeper level, and not necessarily relying on someone reporting what it is that they remembered that they did, or what they think they did, or what they know is the right thing to do, and that's what they're going to put on the survey, rather than what they actually do. So that's actually using some of the technologies that we now have available, and thinking carefully through the way that we could design some tests to actually see the behavior as it's happening in real time. Give a particular problem, obviously do your background in figuring out where the groups are, making an open universe, maybe devise a constrained time frame, but actually watch and be able to see what people are doing, what sources they're going to, and where their eyes are going when they're looking at this. Is just an example of a heat map of tracking where people's eyes are when they're looking at a particular site. So there are ways now that we can devise things that weren't necessarily even available, that we don't have to rely on someone reporting what it is that they think that they do, but actually watching what they're doing in a particular time and space. And you could confine the space, like Sean was talking about, with a limited set of resources. You could leave it wide open, but I think that those are the places, and that's where we probably want to be thinking now, is how we can be studying the actual behavior as it's taking place, in as real a way as we possibly can. And we're way over time, so
We're only 5 minutes over based on the 10 minutes we gave for the express
based
survey.
on the 10 minutes.
We're happy to answer any questions, or we can finish and get into our break. So.
And while people are formulating their questions, I wanted to thank everybody at WestPac. I'm obviously not a WestPac person, being from New York, and I also wanted to thank Sean and David for inviting me. So they're very kind. Questions?
No, Alana has something to announce. Oh, you have a question?
No, I think we're good.
I think so. Thank you, everyone. I have a free night. I have a free night.
He's exactly what he gave to me. So.
Well,
right? I mean, because if I can get 37, I will, right? But if I can do 10 more, well, they need to be able to, because I think that's submitted a copy to the desktop. And yeah, if you're already a member, if you have a card, don't put in it's not a paper if you're not already a member.
Right, actually, they find out if they see me and they get mad. They can,
I don't know that it got it.
yeah, exactly. He's there. If he's there, my kids are on track. But I mean, I was a criminal, so I was, hanging around there. That's like I was going to pay it.
During that again, they links within your local site.
I have links to the web.
Okay, good.
Yeah. Well, it might, hold on, let me try a site just to make sure that I didn't get the URL wrong. Should load. Maybe and my favorite, is hiking trails. And I said, and then I went, a lot of state agencies. What's that? For early hours, no, I'm going to start at 4 o'clock. I still need to
Just kind of hanging out waiting, but I just checked out to make sure because I just opened the browser, see if I can get outside hours, just because I never go there. So I just make an expression. And I was able to get to that point. Now it's something where I guess it might be, I don't know what the PPL is. What's that? Yeah, if you want to check out our website, tell us. Angela's got us there.
That's fine. Yeah. Would you like those before you start? Yeah. That'd be better. Lots of friends and notes. Okay.
Not that first one.
It's okay.
Yes. Okay.
That guy who did the keynote this morning had a little. Is that going to be better?
Yep.
I would like to do that. And also, can I plug an iPad in this?
You bring an adapter along with you?
But I actually, yeah, I did. I actually do on these.
Because it is a 15-pin V3.
Yeah, okay. Actually, the online, I'm not using PowerPoint, although I can use that. I'm thinking about maybe it's a web-based. It's a haiku deck.
I'm thinking about Pezzy.
Oh man, that gives me motion sickness.
Okay, so it's not that.
But it's similar to printing in the sense of the print. I can put the presentation online and just pull it up that way here, so it doesn't matter if it's on my iPad or not. So
do you want to give it a try at the or try like at the end of the day today? Because I'll try the last episode and get to it and see how it works.
3 lessons more. I only have a class.
Small town papers. Small town papers. They're often pretty good, except for the very first one.
Well, and I should actually log out to the Facebook one logins, but I already logged in.
Oh, social media.
Yeah, LinkedIn. Yeah. I just wanted to be logged into them so that doesn't take as much time.
Do you have Firefox? But the default for PowerPoint is IE, right?
Looks like it's lagging.
That one is,
I didn't answer. The phone number, the keys are right, great.
Good afternoon. If I could get everybody to have a seat, resume, we'll finish this up. It's been such a great day. We've had so many great presentations, and I'm really pleased to be able to introduce our final one of the day. This is Kim Asitis. Kim is a graduate of University of Washington, the MLIS program, as am I, though you wouldn't know it by my saying that. She has been a reference services librarian at the Public Law Library of King County since 2001, many, many years there. She's also maintains the library's website. The reason I got in touch with Kim, though, is because she and her colleagues teach numerous classes at the law library. They teach classes on a wide variety of topics such as e-filing, legal research for the non-attorney, searching Lexis and Westlaw, and my favorite, hiding your trail, smart online sleuthing. Kim teaches these classes to attorneys, pro ses, investigators, public librarians, and state agency employees. Please help me in welcoming Kim.
Well, thank you very much for the invitation to come speak at WestPac. I always have to give a shout out to that while I did get my degree in law librarian in the librarianship from here, I am in my heart a duck. So I know I should be conflicted, but I'm not. Okay, so I always like to start with my presentations with caveats because I work with attorneys, So I am not a professional investigator. Professionally, I don't have any licensing or professional training in that particular area. I just happen to really enjoy this area of study. And all of the websites that we're going to be visiting today are completely legal. They're all free. If you've never done a lot of this research, some of it may seem a bit unsavory, but it is, I guarantee you, we're not breaking the law by going anywhere that we're going to look. And I know that not everybody is from Washington, so some apologies. Many of my resources are Washington specific because most of the people who attend are from Washington, but a lot of the strategies that I talk about will work across multiple states. So my apologies if not everything is 100% applicable to your work. Just by a quick show of hands, who does any sort of training either in-house or out on these types of topics? Online sleuthing? Okay, excellent. So this is part of a much larger class that we've been teaching since 2004 at least. It's by far the most popular class we teach in the library. The first thing I always suggest folks do is to have a checklist or a journal or something to that effect. This is just one example. The idea being that once you start opening up windows in your browser, pretty soon you're going to have 10 or 20 windows open and you'll forget, where did I find that email? Where was that phone number? And so if you keep track of where you've been and what you found as you go along, it's a really good strategy. Also, because I work with a lot of people who are actively in firms, they're doing things like due diligence for permission to serve by publication, and they need to be able to show the judge that they did indeed try to find the person. And so having a journal is a great strategy. So on that journal or checklist, you want to start by writing down everything you know about the subject, even if you suspect that it might not be quite right, because you can always go back and change it. And then as you learn more information, like alias, names, that kind of thing, you're going to add that information in. Now, a good starting point is an online Yellow Pages, White Pages directory kind of thing. Now, I used to be able to show you whitepages.com, and it would show complete addresses. And unfortunately, I don't show that anymore because it's now been bought up by an information broker, and it does not give you anything for free. And you'll get the idea that we really like free around here. So I'm very annoyed and frustrated, but not too surprised, because that's kind of the way these things work. Sometimes you'll have an open source sleuthing resource that works one week, and then the next week it's useless. So my new favorite that I like right now is a website called people.com. Now, the UW Gateway is not allowing me to go out to it, but on this site, it does kind of a meta search across a bunch of different information brokers. Some of them are going to give you a lot of information for free. Others are just going to give you little tidbits. But in a couple of the names that I regularly use for my sleuthing because we don't call it stalking, because that's illegal, I was able to get good information that I knew was correct because I had verified it in other places. So consider using people.com as one of your starting points. Now, has anybody used Reference USA? Okay, so Reference USA is something that's available through, here in Seattle, through the Seattle Public Library System and the King County Library System. And I was really impressed with what I was able to find, complete addresses, phone numbers when they were available, the ability to search by as close in as a 1/10 of a mile to the person that you're looking for. So you can say, for example, you're trying to see who lives in an apartment building, and it will show you addresses and apartment numbers. So check with your library system to see if they have access to Reference USA. Now, I know that everybody has access to a lot of different types of paid databases. Some have the Cadillac, and some people have nothing. So I tend to go lowest common denominator and don't make any assumptions about anybody having any sort of paid access. So that's why I try and talk about things that anybody could get to, or they could get to with a minimal amount of effort, like going through your public library system. And then also part of Reference USA is it provides an interesting little lifestyles thing. So they're obviously getting this from things like magazine subscriptions, and it will tell you if they like outdoor pursuits or if they're a catalog shopper, that kind of thing, which I thought was really interesting. Now, paid databases, as I said, the library doesn't have access to any of these types of paid databases. But I find that they can be very good as a starting point, because even though we're not going to go any farther with Intellius, it's giving us a lot of good information for free. So Tim Iman, the non-Washington folks might not know who that is. He is our local initiative guru. Nobody seems to mind that I use him as my guinea pig for searching. He's not particularly popular, so I use him. So here it's giving me for free suggestions on places that he might have lived, aliases, a relative, places that he's worked. So without even having to pay for the next level of report, which they would gladly sell me, I've got some good information that I could add to my checklist. Another website that's similar to that I like using is called advancedbackgroundchecks.com. Same idea. They'll gladly sell you a full background report. But you can get a lot of good information for free, especially because they tend to show you who their associates and relatives are. And when you're working with a name that's maybe a little bit common and you don't have something like a middle name or a middle initial, it's helpful to see who the relatives are possibly, because that can help you to eliminate false positives. So I like advanced background checks as another starting point. Now, in Washington, voter records are public information. Not everybody realizes this, and sometimes this can really freak people out. So, again, my apologies in advance if you've not seen this before. Now, this is the Washington Voter Database. It's online. Unfortunately, the site that has maintained this for a very long time is no longer keeping it up to date, which is sadness. But it's not all bad. If you look at it, it says it hasn't been updated since February 29th of 2012. What happens is that the Secretary of State once a month puts out a data dump, basically. Now, you can online request the CD, and they'll send it to you for free. I tried that out just because I was curious, because this website's no longer being updated. And it was good that I got current data, but they provide you the raw data with a file that is so large that I had to open it in Notepad, get a cup of coffee, after I ran my Control F search, super sophisticated, and then come back. So it's not at all easy to use, but the current information is there for free. You don't have to pay, but you do have to request it every single month if you want the most current information. But the website is still a good resource because of the information it gives you are things that are not going to change. Now you can search this in a couple of different ways. You can search by first name, last name. And this is nice because you don't have to know where the person lives. You can just check to see if they're registered. So here we see Tim. Sorry. Let's try that again. There's Tim. And the jewel of this website is that it gives you full birth dates. So even if the address information is wrong, that's okay, because you have the full birth date. And with full birth dates, that opens up access to many, many other different resources. It also shows you almost all of the address, but then they truncate the last digit, either an O or an E for odd or even. Well, there's really only so many single-digit odd or even numbers. You can usually figure it out. Plus, once you start to add in things like Google Maps, property databases, you can usually figure this out. And the CD that you get from the Secretary of State, those addresses are not truncated, and they do include apartment numbers. So if you're running into a dead end with this website here, and you specifically need to get that last digit or an apartment number, go ahead and request the CD, just to know that the data is going to be a little bit bulky to work with. But you can click on the house number, and it shows you who else lives there. So we have Karen, and I'm going to make the great leap that that's his wife. And this is really cool because you can see who the other voters are. It can also help you to figure out relationships, because a lot of times adult children who are in their 20s or so, they were registered at home with mom and dad, and then they've moved out, but they haven't changed their address necessarily. So the data that's there can be very helpful to kind of figure out who's the sons and the daughters, who's the dads, who's the grandparents kind of thing. Sometimes you can see as many as 3 or 4 generations that are all in one address. So I really like the voter database. It's one of my favorites. I just wish that the folks who were running the Sound Politics blog would keep it up to date. And also, I should have said at the beginning, I have the resources electronically. I will send them to Bonnie. And then I heard tell that you all might get them via email later on. And we'll have clickable links in the PDF. So, and all the websites that I'm visiting are in the materials. So you don't have to be taking any frantic notes of URLs, because who's got time for that? Okay. So birthdatabase.com is another site that I like. And it's kind of typical of this type of thing. They say they get their information from public records, but they don't necessarily say where. It's one of the few places that I found that also lists the birthplace. So when I look up Tim, we see his full birth date and his birthplace in Yakima, Washington. But when I search for myself, I don't exist. I know I was born. And I searched on all my different variants of last names, and I don't exist. So that's, while frustrating, is not particularly that unusual for this type of site. That's why you have to know about so many. My larger skip tracing class materials are like 12 pages long, and that was from when I pared it down from 20. So there are a ton of these types of sites, and I'm just showing you a few of my favorites. Now let's say you want to know about things like marriages, death, and property. Washington, again, has a really awesome resource called the Washington Digital Archives, and you can search this site by a lot of different ways. And I'm going to show you one example. You can search across all of the resources, or you can limit it to one collection. And in this case, I'm going to limit it to death records. And we'll see, this is my husband's spinster aunt, and it helps to have a unique last name when you're doing this kind of search. And we can see here that it shows us when she was born, when she died, and her social security number. Now, social security numbers are, of course, private when the person is alive, but once they have been reported as to the Social Security Administration, they are public, and you can search them. Now, this site does not allow you to search by the social security number itself. There are a couple out there that do, but this one does not. But it can be useful even when you're looking for people who are alive, because if you are again, sleuthing, not stalking, them on social media, and they may make a mention of, Great Aunt Gertrude died and I'm going to her memorial. So you can look up Great Aunt Gertrude, figure out where she died, and then you could look in that city's obituaries and figure out where the memorial service is being held. And that might be of use to your process server, perchance. So I did mention unsavory, yes? Genealogical stuff can be a really good resource because, again, sometimes the information you have that's really good is maybe a generation away from the person who, I know it's this guy and he's got this Uncle Johnny that I know a lot about, but I'm not so sure about him. So if you can kind of work backwards through relatives, that can be a really good thing. And also the obituaries themselves will include things like who the surviving family members are, where they live, that kind of thing. So it can be an excellent resource. And the death index is just one. They have property records, marriage records. The one thing I would say, this site tends to be a little bit better for slightly older records. You'd want to check the scope for the particular database. So, for example, King County, after about 2000 or so, they stopped submitting their marriage certificates to this database, and you have to go through the recorder's office. So it's always a good idea to check the scope notes of the database to be sure that you're not searching for something that's actually not there. Yes?
Are there divorce records in that?
Yes and no. So in the digital archives is access to Superior Court records from 3 different counties. Chelan and 2 of the others escape me. Now you can't look at the data directly, the scanned in images, but you can do keyword searches against it. And it's actually really darn cool because you can actually search by the keywords that might actually have appeared within a description of the document, which is more than you can do with a lot of the things like ECR, which is a King County product, or Lynx, which is a Pierce County product. It actually allows you to do more searching, so if you're looking for a type of document, and then you pay to see the records. So for those 3 counties, you can do some searching. But again, it's going to be limited by the date range of whatever they've submitted. Now, again, apologies, it's King County centric. So in King County, we have access to a really awesome resource called a parcel viewer. Now, this resource allows you to do, there we go, searching by address, by street intersection, by parcel number. And the cool thing about this particular resource, it's a lot of cool things, is that it brings together information from a bunch of different county departments all into one spot. And so now you can't search it by property owner's name, but I will show you in a moment how you can work around that. I used this product, or the first generation of this product, a few years ago with a patron who was going through a divorce, and she suspected that the estranged spouse was hiding a piece of property that hadn't been declared. And so she didn't know the address, but she knew the approximate street intersection. And so by using this product, we were able to zoom in and identify the parcel that she thought might belong, and it did indeed, that the husband was the taxpayer on the parcel. So this particular parcel belongs to our neighborhood multi-billionaire. This is the Gates residence. Now, you know you're doing pretty well in the world when they name your house in the property records. So it's being a little cranky with me, so I won't go any farther, but basically this would put you into property tax information. $1 million a year is how much you pay, is a description of the house, the parcel number. And I would say this would be useful in any sort of property research where you have an assessor taking a picture that's made public. Oftentimes, the pictures that the assessors take are from a standpoint that you couldn't get to. Now, because I'm not a PI, I wouldn't do any sort of in-person surveillance. But the assessor's pictures on these property research lookups are often taken like from the driveway of a property. Now, you may not be able to get to that driveway. And so that picture may be a better tool than you could get yourself, either physically or wouldn't feel comfortable getting that close. So consider that a tool. I know one of my students used the assessor's picture to be able to zoom in on a pickup that was parked in the driveway of a business, and by looking up the plate number, he was able to figure out who actually owned the business. So that's a tip for these types of property research database, and that's going to be relevant regardless of the county that's providing the data.
Google Street View is also good for that very same reason.
Except that they've now started to blur the license plates on that's fairly new. So which is great from a privacy standpoint, but from an investigative standpoint, it's darn annoying because, yes, you used to be able to zoom in on the plate numbers in order to see, what was parked in front of a business or a house or something, and you can't do that anymore. At least that's their goal. They may not get every single plate, but they definitely seem to get most of the ones I've tried to find. Now, I mentioned that you can't search this parcel viewer by property owner's name, but what you can do is you can go to something like a recorder's office search, and probably any county that's of a decent size is going to have something like this. And then you can search by a taxpayer's name, and then you can find the property documents, and then you can look up either the parcel number or the address from the documents, deeds of trusts, mortgages, that kind of thing, and then you can look those up in your parcel viewer or equivalent database. So that's one way you can work around this. Now, I don't have it in the presentation, but I'll mention the property database Zillow, ZILLOW.com. And people may be familiar with this from a real estate perspective in terms of looking for houses to buy. The awesome thing about Zillow is that it lists properties even if they are not on the market. And if they come from a county that has online property records, you can look up the property and then they will link back to that county's online property database. So you don't have to do a bajillion Google searches to be like, I wonder if Tallahassee, Florida has online property records. It doesn't matter. You look up the address in Zillow, and if they have accessible online property records, you'll know that because the description that Zillow provides will handily link you back into the property database that the county provided. So I think that's pretty cool. Okay, so did anybody used to use Google News when it didn't suck? Yeah. This is a sadness. It used to be awesome. It had this great archive that you could go back and search, and they took it away. It's so annoying. So here is an example. This is the gentleman Samuel R.B. Harris. Now, in the history, the pantheon of criminals, he's not doing so good. He and an accomplice broke into the Esquin wine storage facility south of the stadiums and proceeded to steal hundreds of thousands of dollars in wine. And they blacked out the security cameras, but not all of them. And the property owner was able to recognize him because he had been a customer of the shop. They also tried to burn down the building unsuccessfully. So they arrested him, and when they were doing their searches, they discovered that he had a notebook in which there was a page titled The Plan. Yeah. So anyway, he is one of my favorite searching guinea pigs. So when I do a news.google.com's phrased search on Samuel R.B. Harris, I get 0 hits, which I know is wrong. Because when I do it as a phrase search in the total web, I get 10,000 hits. So this is an example of why you shouldn't rely on the Google News search anymore, because it doesn't work. Instead, I've found a couple of replacements. This is yougotthenews.com, and when I do my same phrased search, I get 5 hits, and they're actually from news organizations. Whoa. There's also, online newsstand things through your local public library, ProQuest databases, all that stuff. So just be careful if you used to use the news feature on Google. Just be really suspicious because it's not giving you everything that used to be out there. Another one of my favorites is smalltownpapers.com. So this is exactly what it sounds like. It's 250 plus papers from small towns around the country. A lot of them don't even have a website for their newspaper directly, but they submit them to this repository that scans them. And then you can do keyword searches against those scans. Because a lot of people think, oh, well, I'm absconding from justice, so I'll go live in a little small town. And that's actually a bad strategy, because people in small towns tend to gossip a lot about things. So you can find, the local gossip column, who's been sick, who's visiting, who came for Thanksgiving, marriages, births, all that kind of stuff, and can all be keyword searched through this website. So if you know the person is living in a town that has coverage in this particular website, this is your new best friend, and it's not. It used to be part of the Google archive, but it is not anymore, as far as I can tell, or at least not consistently. So consider using smalltownpapers.com. Now, criminal history. And this one is good because it's applicable outside of Washington, even though my example is going to be Washington specific. So most Department of Corrections out there provide an inmate lookup. I like this one in particular because it provides you, at least Washington's Department of Corrections doesn't provide you nearly the same amount of information that this particular website does. So you go in and you search by the offender. And in this case, we're going to use Gary Ridgway, which Green River Killer, that's his name. It's not his name, that's how everybody knows him. And what's cool about this site is that if you're searching for someone with a common Joe Smith kind of name, it has an age range pull down, so you can limit the results to a range of ages, or if you know the person's birthday specifically, you can enter that in as well. And then once we pull this up, we have a complete birth date, an age, race, gender, and a custody status, and aliases. Anytime you see alias information, you want to write that down on your checklist and then go back and run those names again through some of the same places you were at before to see if something different pops under the alias name that you didn't get under the original name that you had. So criminal records are an excellent resource for getting things like complete names and birth dates, because obviously they don't want to screw that up. So they will often show you the birth date information, whereas other places may not. So I really like this FindLink website. The actual purpose of the website is victim notification. So crime victims can sign up to be notified in advance when an offender has a custody move coming up, either to a new facility or being released into the community. So that's its main purpose, but its secondary purpose is quite nice for the investigator because it releases all this information. Okay, next up. Now, this is the National Sex Offender Search. Now, pretty much every jurisdiction has a sex offender search of some sort. I like this one because it allows you to search across the entire country. Now, there's very few countrywide searches of any kind that aren't pay. So if you don't know where the person is, but you know they're a sex offender and wherever they are, they need to be registering, you can do this search here and searches across the entire country. So you could do a first and last name search, or you could search by location. Now this is another one of those ones where you have to give some information, fill in one of those CAPTCHA thingies. Now if you've never done this kind of search, you may have wished that you just lived in blissful ignorance. But let's say you decide to be brave and you go ahead and search. Now I entered 98104, which is the zip code for the courthouse where I work. We also happen to be the sex offender registration point because there's a sheriff's office there. So we get a lot of people, especially those who are transient. And so when you pull up a record for someone, provides you with a picture. Now, pictures are very powerful when it comes to doing this kind of sleuthing because that can help you to narrow down, yes, I know this looks exactly like the person I'm looking for. I'm like, oh no. Or it could be, this is totally not the person. Even though the name matches, I know it's not the right person. And this gives us aliases. It gives us a name, identifying characteristics, and it even gives you a handy link into the statute that they violated. So I like this as a sleuthing resource. And again, because it has that nationwide coverage, it's really nice. Now, this is the most wanted program through the Department of Child Support, and a lot of agencies are going to have something similar to this. So what this does is for non-custodial parents who are not in compliance with their child support obligations, the custodial parent can give permission to have their name and identifying information posted on this website. And then they release a lot of information. So we've got a picture, a birth year, height, weight. What I thought was really interesting is an occupation. And sometimes that occupation can be helpful to add to your list, other info. So this is another resource. And sometimes the backgrounding you're doing is not so much where is the person, but more, is this a person we want to hire? Or is this a person I want to rent to kind of question? So knowing this kind of backgrounding is an important thing to know. Yes?
How good is Smoking Gun in its coverage? And also, are there commercial mugshot sites, or where do they get all these mugshots?
The Smoking Gun definitely has interesting things on it. I've used it in the past, not all the time. I think it just depends on the profile of the person they're covering. Higher profile people are going to be more likely to have stuff on Smoking Gun. If you're not familiar with that, it's just like what it says. It's smokinggun.com, and they do all sorts of really interesting things, including investigative scoops, basically, that people have submitted paperwork and things. I mean, you'd have to be a little bit careful because some of the stuff that they may provide might not have been given to them in the most lawful fashion. But it's going to depend on the person that they're covering. And then in terms of commercial mugshot, it's going to depend on the agency that takes the mugshot. Some, I know there's some Oregon agencies that release mugshots just to anybody. So it's going to depend. Washington, at least in King County, doesn't do that. They don't put them out publicly. So it's going to depend on whether the agency itself provides the mugshot on just a regular basis or whether it's something that has to be requested. So it's going to depend.
And I think Oregon passed a law, I'm not sure it has to do with it.
Yeah, and there have been some stories of people who've been basically held hostage because their mugshot showed up on a commercial website that got linked to their name, and then they tried to extort money from the person to get the mugshot down. So that's a concern as well. So courts information, I'll go through this quickly since you probably already know this. Just in case, say, for example, your PACER access blows up and you can't get to it, I just want to let you know about a website called Recap the Law. And what it is it's a Firefox extension, and people who are PACER subscribers and have Recap installed, when they go out to PACER and they decide to purchase a document, that the extension automatically takes that document and it pushes it up to an archive. You can search the archive for free. So it's a pretty cool tool. So you get free PACER documents, and you can search the archive without having to be a Firefox user, because I know that not everybody's allowed to use alternative browsers. So it's a good resource to know about. Of course, Washington State court records. We are very lucky in Washington to have very robust access to court records online. Not every state has that. So in Washington, you can search by name across the entire state. I would only say that Seattle Municipal Court is its own beast, and they don't have the greatest coverage in the court records. And I'm going to show you how to search their website and a couple of little tricks that you might not have known about in a bit. But we're really lucky to have coverage, as we do, through Washington State Court's records. So Pierce County, they have a system called Links. Now, I really liked Links even before their trainer came and taught a class for us. But after the trainer left, I liked links even more. It's just awesome. It gives you a lot of stuff for free. It's easy to use. It has everything Pierce County in one spot, whereas King County, you have to have like 5 different logons to get anything. And they have this really nifty sleuthing thing. So here's an example. So LaTanya Clemens was one of the co-defendants in the 2009 Lakewood officer shooting trial. There were 4 officers who were gunned down in a coffee shop outside of Lakewood, Washington. She was one of the co-defendants. Her convictions were overturned on appeal. But what's interesting is the links information that this provides. All the way down at the very bottom is co-defendants. So if you're sleuthing for friends and associates, knowing who someone's co-defendants were on a criminal case could be a very important thing to know, because what do friends and family do? To go and commit crimes together. So if you suspect that someone is surfing on a couch, this would be a legitimate place to look to see if they might have been involved in a criminal case in the past and who their co-defendants might have been, and that gives you more names to search on. So this is just one of the reasons why I really like the Links product. Now, Seattle Municipal Court records. I mentioned that the coverage is not that great on the court's website, so you really should search it directly. As of June 24th of 2014, they have published a new service, free online full text access to Seattle Municipal Court cases. Wow, that's really exciting. It doesn't display on Firefox very well, so you have to use IE. That would be the only thing. So if you have to do Seattle Muni Court research, remember that they have this new system. But what I'm going to show you is ways that you can work around the Washington State Department of Licensing. Because what can happen is if you've got a license plate number and you want to know more about it, typically you'd have to submit a request to the Department of Licensing saying, I want you to pull, give me information about this license plate number. And then, depending on the industry type, that subject would be advised that you've requested that information. Now, depending on the situation, that might be a big deal or it might not. But let's say you don't even want to worry about it. So this is a way you can work around it. If you have the plate number and the stars are aligned and it was involved in a case in Seattle Municipal Court, we did 5 clicks in about 10 seconds, or even less than that. We've now gone from a plate number, which was OSITI, which is the vanity plate for my husband's car, because this is his penance for ignoring carpool-only signs. We now know his full name, Michael R. Ocetus, and his date of birth. And if he had any aliases, that would all be listed there. So now we've gone from a plate number to a full name and a birth date and any alias information in 5 seconds and 5 clicks. And you can also go the other direction. If you pull up a defendant name and you're like, I wonder what kind of cars they might drive, you can enter them in here. Case number, citations. Oh, looky, there's a vehicle. So now we have the vehicle. We know that it's a 2002 Honda Odyssey that is silver. That's a lot of information. It was free. It was fast. Now, this is not always going to work, obviously, but Seattle writes a lot of tickets, and it was free, and it took like a minute. So it's definitely worth it to check to see if your subject might show up in this system. There are no other cities in the state that I'm aware of that have this sophistication. So, again, kind of the stars have to align, but it's definitely worth taking a look at.
Kim, can I ask you a question?
Sure.
Does this database also include the driving through the red light camera kind of tickets, or is this just...
I would say that it would if it was issued by Seattle Police Department. I would think so. Yeah. I haven't tested at that, but I would think so because it's an infraction through Seattle Municipal Court, so I would think it would be there.
Should she search you?
Possibly, I don't know. And then I'll just mention just a shout out. You guys probably already know about this, but Google Scholar is an awesome resource for case law. Again, if Westlaw and Lexis blows up or you're working with someone who doesn't have access to that, Google Scholar is an awesome resource for 50-state case law, federal. They even have the federal supplement coverage about 1950 on, except for the U.S. Supreme Court, which goes much farther back. But keep in mind Google Scholar if you don't have access to your other standard paid databases. Now, a couple of things on businesses. What I usually start with is the Secretary of State for the company, for the state that I am looking the business for. But remember that businesses don't have to be incorporated in the state that they operate in. In fact, if you do a search in your state department of there's your corporation's database and you don't find anything, check Delaware. Delaware is known as a corporation-friendly state, and they do a lot of corporation registering. Unfortunately, sometimes people will use things like third-party registration company, and then you can't get any farther, which is a little annoying. But that's a little tip. So if you can't find it within your home state, check Delaware. Now, Washington uses a unique identifier called a UBI number. And if you have a UBI number for a company, you want to write that down because a lot of companies have very similar names, but their UBI number is consistent across all the different state agencies. So, for example, in the Department of Labor and Industries, which has a really powerful website, and I'm sure other states have things that are very similar, with the UBI number, we can find actually a great deal of information. So the gentleman, Samuel R.B. Harris, worked for actually, I'm going to use a different search than the one that I had planned, and hopefully this won't blow up on me. Green Tea Plumbing. He founded a company called Green Tea Plumbing. Now, what was interesting is that it had an address. And I know that this is his correct address because I was preparing him as the subject for a class that I was teaching that included investigators from the Washington Department of Revenue. And I had them come visit me at the library, and I'm working through this sample, and they were all excited. And they said, "How did you pick this guy?" And I'm like, "Oh, I just heard about him on the news." And the lady said, "I filed that lawsuit against him, the one that's listed down here at the bottom of the page." She said, "I filed that lawsuit against him. How coincidental that you just happened to pick somebody." And she was able to confirm that that was indeed the correct address. So that's a tip. When you're thinking, okay, bust on the voter database, that's old. Where would they want to be sure that they had a good address? If they're involved in litigation, they want to be sure that they have a good address with the courts. If they're licensed, they want to be sure that that agency has a good address for them. So you have to kind of think, where's the most important place that they're going to be sure that they keep their address up to date? And for him as a contractor, keeping his address with L&I was obviously really important, even though he let it lapse and he got in trouble, and now he's in jail. This got me a lot of good information. So that's that. Okay, so now this is about vehicles. So now we've got a plate number, and let's say you needed a VIN number because there are some databases out there that are like stolen vehicle databases, and you need a VIN number in order to search them. You think, well, how do I get a VIN number? Well, if you put the plate number right there, there's the VIN number, there's a report for emissions, and you can even go so far as to figure out which station that report was taken at. And there's a little handy legend that tells you which station goes with which station number. Now that could help you. I mean, it's no guarantee that the owner of the car happened to live in the same city where they got the emissions test done, but it would stand to reason that it's probably close by. So again, if you're trying to narrow down your search, knowing where someone got their emissions test done, and the fact that they're still getting it done every 2 years, that's another thing to know. Okay, they got it done recently, probably still driving that car. And if you were working with a private investigator, you would know details about the car, like the color, all of that stuff that you could give to them if they were going to go do in-person surveillance. Okay, so the last bit we're going to talk about some social media. Now, a lot of people use Facebook. What you might not realize is how incredibly powerful Facebook has now made this graph searching. Anybody played around with the graph searching on Facebook? Oh, I love showing things that people haven't seen before. It makes me so excited. Okay. It used to be you would just, type a name of a person that you were looking for, but it's gotten way more sophisticated. So let's say you found a name out there, say like a Yelp reviewer. Yelp bios have a ton of stuff. I found this lady named Trish Ann C. She said she was from Seattle. She likes photography and has a photography website. So I went on to Facebook and I said, women who live in Seattle, Washington. Oh, hold on. Sorry, I forgot. Women, but I don't know her last name. Trish Ann, who live in Seattle, Washington, and like photography. There we go. There she is. So we've used. So it's now. Okay. You have to know how Facebook structures. It's not like a Boolean search where you can just start chucking stuff in there. You have to do it just so. You have to structure it just so. But if you figure it out, we're just mining the information she's made public. We know her name, we know where she lives, and that she likes photography. And there she is. But you can also use this. So say you found a subject who hides their photos or their friend, which a lot of people do. So here as an example, if I say photos, come on. Photos by Kim Ositis. This is only going to show photos that I've taken. And so let's say you've looked for the person and they've hide their photos. You can't see them. But if you change this to photos of Kim Ositis, you're now looking for any photo that I've taken plus any photo where I've been tagged by somebody else. So that's a way you can get around people's privacy protections. You can also start to put together things like people who are friends of X and Y. That can help you find relationships. And then there's additional refining you can do over here where you can say where was it taken, when was it taken, who commented on it, who liked it. So there are very, very sophisticated searching tools within Facebook. And some of them you can use to, again, kind of work around people's privacy restrictions. Another thing you can do, which is pretty darn cool, is you can search by hashtag. Now, this gentleman that I just taught for 4 hours on Wednesday at a DSHS Office of Fraud Accountability training on social media. And I showed him this search. There's this guy that I've been sleuthing, not stalking, whose name is Sean Banerjee. Now, on his Instagram profile, it's private. I can't see his posts. But in his profile, he included a custom hashtag that he'd come up with himself called Banerjist. Now, anytime you see something that's so unique to an individual, write that puppy down. You're going to use it to search in other places. Facebook allows you to search by hashtag now. So when I do a search on Banerjist, I get one hit. And there, guys, my guy, Sean Banerjee, being tagged by someone else using his unique hashtag. If I go in and I look at Stacey Ann, she doesn't share her friends, but she shares her followers. And don't you know, one of her followers happens to be Sean's dad. One of his followers happens to be Sean's mom. And I know this. There she is. Because the profile picture, that's him right there.
Go back one screen.
Sure.
Again, 'cause it looked like there was a Sean Banerjee to the left of her.
Well, yeah, that would be one of his friends. But see, I couldn't make the link from Sean to his parents because he hid his friends. So I'm working, so you can, if someone hides their friends, you have to kind of friend by friend rebuild their friend list by going around it because you can't see it directly, so you have to look at where the connections are. So that's a technique. I'm going to keep moving. I think my next slide is LinkedIn. So LinkedIn is something you need to be really careful of if you're using it as an investigator, because you may not realize that, like with most of this social media stuff, the default is openness. They want you to be open. They want you to share. You may say, I don't feel like sharing. So you go under, you log back in because it logged you out. So you go under privacy and you say, select what others see when you viewed their profile. The default recommended is if I view somebody's profile, they will see my name and my picture. An investigator, not so much. So you need to change that, and you need to check that, because if you're using your own profile to go out and sleuth people, they'll know. Now, the flip side of this is that because I've selected to be completely anonymous, I can't tell who's viewed my own profile. So there's kind of that give and take. LinkedIn is like, okay, fine, I'll let you be anonymous, but then you can't tell who's looking at you. So that's the give and take with LinkedIn. Next up. Okay, so now let's talk about things like usernames. Usernames are very powerful because a couple of things. People are lazy. They pick a username when they really like it, and they don't want to change. They're going to use that same username website to website. You can also sometimes take someone's email address, and if it's a personal email address, it's not going to work so much with a work one. Lop off the @ whatever and search on just the first part of the email address, and sometimes you can pop on things on that. This is Topsy. It searches across a lot of different things, including specifically Twitter. Now, Twitter has an advanced search page. When I do my search that I'm going to show you in a bit, I only get one hit. And this is the search that I'm going to do. I know this is Will Wheaton of Stand By Me fame. And he's tweeting about the hashtag beer. And we see that in the past 27 days, a bunch of people have tweeted. Now, this is the key thing, is that these are all of retweets and his own tweets. But if you say, I only want to see stuff that he's written, you go under the advanced search and you limit it to @Will Wheaton, specifically with this word, beer. And now we are much more limited to just his tweets. And this goes all the way back, to the beginning of Twitter, which is like 2006. And the advanced search that's built into Twitter does not go back that far. So you can use this to do a lot of powerful things. If you're following someone and you're like, oh, they talked about that one thing, but I don't want to have to scroll through, months and years of Twitter posts. This allows you to search. Or if somebody says, well, I couldn't have done X whatever because I was over here. And then you can look back by time and you can say, well, they were lying because they posted about being at this one place at this one time. I can tell that because I could look at their tweets when I searched it by a topic. So, and if we change it to everything, as it starts to bring in YouTube, it's really powerful. And this is just one of the social searches that are out there. There's a number of them. I like this one because it's not as restrictive on date. It purports to go all the way back to the beginning. And did you know that the Library of Congress is cataloging every public tweet since the very first one. Yeah. So we'll know what people had for lunch for centuries in the future. But social media can be, this sleuthing is like the next step. This and images. I have professional tips. Here's my professional tip. I didn't really do much in the reverse image searching, but it's very powerful. You have to be careful when you're doing pictures, because pictures stay around. Even if you closed your Facebook post, anything that wasn't private has been scraped and is living on multiple servers out there. This is also a cautionary tale on usernames and adult websites. So let's say you frequent adult websites. You can do whatever you want with your private time. I don't care. Don't create profiles on adult websites. That's number one. And if you are, pick some username that you don't use anywhere else. Anywhere else. Don't use your picture. That's you. Don't use the same picture, that's you, on that adult-oriented website that you also use on your Google Plus profile with your real name. And I wish I could tell you this was a hypothetical. It is not. Yeah. My computer needed, a blessing after that. It was traumatized. So you have to be really careful, because pictures, they have a lot of data attached to it that you can't see. Things like geolocation, tagging, the date the picture was taken, the type of camera it was taken on. All of those things can be gleaned, and then they can be used by folks like me. So you have to be careful. So that's one of my cautionary tales. Okay. Now, I mentioned a lot of Washington stuff. But you say, Kim, I don't live in Washington. That's okay, because this is a website called blackbookonline.info, which is one of my favorite sites. I was asked to go to New Jersey a couple of years ago to teach skip tracing, and I didn't know that much about New Jersey besides Snooki, and I figured there's got to be more. So I pulled up New Jersey, and I said, view all New Jersey records. And the thing I love about this site is that, yes, there are ads, but there's actual, real, honest-to-goodness, useful information. Because if you've ever done things, like California Public Records, it's endless circles of websites, but never the actual website where you can actually put a search in. This has actual websites that are linked. Oh my gosh. And they tell you what coverage is, whether it's state, county, city, who provides the data. You can report a broken link, you can vote on it, and it takes you to an actual thing. My favorite that I found was the casino exclusion list with pictures. Oh, it was good fun. So this is an excellent resource if you need to move outside of an area that you're not familiar with. Same idea is PIBuzz.com. This is maintained by a private investigator called Tamara Thompson down in California. And she puts together all sorts of stuff. She was the one who turned me on to this idea of using Yelp profiles to figure out, to do sleuthing on people, because the amount of information that they include you can use in a lot of different places. But she has all of these favorite links. And she has a whole separate website that catalogs all of her favorite links. And she's the one that you can read about, what's the new way to search LinkedIn or something like that. So it's an excellent way to get to stay up on what's the newest open source sleuthing thing. She also has a very comprehensive list of government databases, things like government employees, government salaries, that kind of thing. So it's an excellent resource, and I'm out of time. It's 5 o'clock. So questions? No questions? Okay. Yes, go ahead. I don't do any. I've thought about it, but I haven't. The question was, do I do any consulting as a professional, or do I just teach? Right now, I just teach. I've thought about it, but I haven't figured out a way that would allow me to keep my job and do it on this side. There are a lot of people who do this kind of stuff as a profession, but right now I just teach it. And other people, and I have to share my final anecdote. A couple of years ago, I was teaching to a group of attorneys at a CLE, and a gentleman came up afterwards, and he said, Kim, you are the scariest person I have ever met. And I said, thank you, because obviously I look incredibly threatening, but don't piss me off because I know where you live. So Thank you very much.
Nice to meet you. You're well, and that's the second reason. Your father, he's coming and mentioned me anytime. Oh. So, and your picture in picture from what's happening. Nice to meet you. Good to meet you. So we'll mention that. Got the period.
Oh yeah. Well, I keep telling them like something important because. That was great.
So I love Topsy because Roby was unfollowed him on Twitter, and he had this tweet from years ago about ceramic cushion papers, and it's like this probably way yeah, just be sure that you shape with the answer to make sure that you okay. Not everybody. I know. The most correct. You don't have to be just for hashtags, right? It can be. Wow, that was fabulous. Yeah, no, that's great. Yeah. It's so funny. I'm like, wait. I just want to thank you so much. This is a great one. So I really look forward to it. I'm not sure how we're going to, but Rita had reminded me that you're doing these virtually. Yeah. And she's doing a lot. Right. John and I can get some of our county law library.
Sure, I would be happy to do that. Yeah.
Anyway, thank you very, very much.
I just wanted to say hello. Hi there. I better not. He's on Facebook, and that's as far as I can be able to find him. Actually, the girls was the one who was all like, "Oh, Mom, you got to try this out, try that out." I actually heard the alerts that
So what would how would get what would trigger it?
You tell it, whoever joins me,
Okay. And you say, thank you very much.
it's gone, then I'm going to lock down the room. Yes. No, it was off. No, you don't. Thank you.
What was your name?
Lenny. Yeah.
Lenny.
Yeah, because what I'm doing, I am the last person to leave, so I'm gonna lock the doors, turn off the lights.
Yeah.
Though I don't know what time I open up back up in the morning.
9 o'clock.
Okay. Well, yeah, I know the event starts at 9.
I'll be here about.
Yeah, I get here at 8, so hopefully no one's gonna unlock it before 8. But that's a question I don't know.
Well,
but I think it should be safe for that brief amount of got a little bit of time to say if custodial service come in, I'm thinking that's got to be a very small window of time. I'm kind of hoping. Yeah. Yeah.
I won't be my computer, but just my.
The monitor, yeah. I mean, I think leaving the monitor out, that's going to be fine.
Okay, cool.
Yeah, I think monitors are.
Who cares?
It's not as hot an item as a laptop. I'll put it that way. It's not as hot an item as a cell phone, you know, a smartphone or a laptop.
Right.
Yeah, unless it's gonna be a plasma, running industry, micro something really small, like they kind of firefighters will look at it like, okay, keep moving on, right?
I know I've had this thing forever. Carved round like this.
They want a bigger screen. Everybody wants a bigger screen. Yeah. Yeah, that would be okay.
All right, appreciate it.
See, where's my mics? Oh yeah, I need to create handles like that. Shots, a little bit jigger shuffle. 4, 5, and 6.